Coming up next on C-SPAN, we continue our look at federal securities laws with Thursday's hearing before the House Energy and Commerce Subcommittee on Oversight and Investigations. At the witness table is Frederick Joseph, Vice Chairman and Chief Executive Officer of Drexel Burnham Lambert.
The subcommittee will come to order. Yesterday, this subcommittee held its first public hearing on high yield, or as they are more commonly called, junk bonds. This subcommittee is a subcommittee of the body which passed the Securities Act of 1933, and in the following year again responded to market conditions and urgent public need by passing the Securities Exchange Act of 1934. Both of these statutes and a number of subsequent federal securities laws were passed by the Committee on Energy, the Committee on Energy and Commerce in its former name of the Committee on Interstate and Foreign Commerce. Pursuant to Rule 10 of the Rules of the House, the Committee on Energy and Commerce is responsible for all bills, resolutions, and other matters relating to securities and exchanges. That same rule imposes upon this committee the duty to review and study on a continuing basis the application, administration, execution, and effectiveness of these laws which are in the jurisdiction of this committee. Indeed, under the rules, the committee is required to establish oversight mechanisms and is urged by the rules to create an oversight subcommittee to pursue questions relative to faithful execution of the laws and the need for additional legislative action by this body and by the Congress of the United States. Pursuant then to the requirements of the rules of the House, the Subcommittee on Oversight and Investigations has instituted a continuing round of investigative hearings with regard to all aspects of the securities market. The concerns of this subcommittee have been heightened by a number of events in the securities market. We have been troubled with insider trading questions. We have been troubled with questions associated with the collapse of the market last October 19. And the subcommittee is, of course, concerned about supervisory questions, the behavior of the self-regulatory organizations, and also of the member firms insofar as dealing with their responsibility over their several employees. The subcommittee is concerned about the liquidity of the market in junk bonds, and is particularly concerned about events that might be attended by an extended economic downturn. The subcommittee is aware from our analysis of public records that significant quantities of junk bonds are currently held in the portfolios of a number of federally insured savings and loans and other institutions whose which, if adversely impacted, could have serious consequences on the national economy. We have questions about the stability of those investments, and we know that a number of insurance companies and mutual funds have used and continue to use junk bonds to help improve the financial performance of those institutions. The Chair is keenly aware, a proper and a necessary role to be performed by the issuance of junk bonds, and that they can and do provide valuable assistance to new companies and to others in financing activities that might otherwise be foreclosed by lack of adequate funds and ability to properly carry out those activities. At the same time, the committee is concerned that the market remain liquid, that the market remain orderly, and that events which could adversely impact the overall character and the public trust of the market do not generate difficulties which need not obtain. We are also concerned about the general rules attending all securities issuances, and we are determined that those rules shall be observed. And the committee is particularly aware of and fully determined that the announcement of the President Roosevelt in 1933, still be followed. Let the seller also beware, and parenthetically, the Chair would observe, let there be a market in which there can be sufficient public trust that the nation can have a market system which will see to it that our financial and capital generation markets serve the necessary function of providing a means and an opportunity for growth and opportunity for all Americans. The subcommittee wants it clear, for the record, that it has received no information, including documents or otherwise, from the SEC or from the Office of the United States Attorney in New York. The purpose of this investigation by the subcommittee is of legislative character. We are looking to find out what is going on in different parts of the marketplace so that the committee may take the necessary steps to perfect the laws in the broad public interest, to maintain the trust and the affection of our people for our capital markets, to maintain the confidence of this nation in the integrity of those markets, and to derive the benefits which flow from that kind of trust and confidence. The proceedings of this subcommittee are directed towards ensuring the adequacy and the effectiveness of federal securities laws. We appreciate the presence of our witness today, Mr. Fred Joseph, and we hope that he will be able to assist the subcommittee with his insights and his observations. Chair recognizes the gentleman from Virginia, Mr. Bliley.
Thank you, Mr. Chairman. We meet again today to examine the high-yield bond market. Our particular focus, as I mentioned yesterday, is 3 transactions in which Drexel Burnham Lambert, acting as underwriter or market maker for a high-yield security, engaged in trades in those securities with Drexel employee accounts. High-yield bonds have become an essential type of financing mechanism for many companies. This financing has produced employment and growth in our economy. I've learned that in my own state of Virginia, where 162 corporations headquartered or with significant operations in the state have issued high-yield securities since 1977, raising over $31.9 billion. This number, by the way, does not include financing for any hostile takeovers. Our job today, of course, is not to discuss generally the benefits of this market, but to focus on potential problems. If there are problems or irregularities in the way this market operates, they need to be identified and cured so that we may maintain the integrity of this valuable market and allow it to continue to operate efficiently with the public confidence. The subcommittee is still at the beginning of the learning curve in terms of understanding how the corporate debt market works and how the law applies particularly to transactions in high-yield bonds. We must begin by looking at facts of particular cases, and through these facts to gain an understanding of the marketplace and the law. Our investigation thus far has produced a number of opinions on how the high-yield bond market operates and how the law might apply to particular transactions. I find it interesting that we have not found cases directly on point involving issuances of debt under legal theories such as SEC Rule 10b-6 and the NASD free riding and withholding rule. That will be discussed today. Although the words of the rules apply to all securities, it appears that these laws have not been applied to debt issuances. I'm interested in learning why this is so. One theory that has been suggested is that these types of securities law violations are not easily found with debt issuances because of the nature of debt, because debt is essentially fungible. The possibility of manipulating the price of debt is negligible. We need to test that theory and to see if the high-yield debt market operates differently from equity markets and other debt markets, and whether some of these types of trading practices are in fact improper. My only point here is that an understanding of the high-yield bond market is essential to an understanding of the law and public policy in this area. I am looking forward to Mr. Joseph's testimony, and I am sure it will assist us in understanding these issues. Thank you, Mr. Chairman.
Chair thanks the gentleman. Chair recognizes the gentleman from Oregon, Mr. Wyden.
Thank you very much, Mr. Chairman. I want to commend you, Mr. Chairman, for undertaking this inquiry and say that I believe you've shown great concern for procedural fairness in this matter, and I think that's something that this member very much appreciates. Mr. Chairman, I have just a few points that I'd like to make at this time. In defense of high-yield securities, junk bond advocates often point out that all junk is not created equal. Specifically, that some issues are such good investments that they're highly sought after. It will be interesting to see if Drexel Burnham employees have practiced what they preach. Drexel has, according to Mr. Joseph's opening testimony, permitted its employees to invest in new bond issues that the firm is selling to investors. In my view, such a practice brims with opportunities for conflict of interest, and I think it's particularly noteworthy to learn that major competition to Drexel prohibits such trading. The trading, Mr. Chairman, appears to be widespread. I've obtained a list of the accounts called by Drexel Burnham employee accounts, but by the SEC insider accounts. There appear to be 33 of them. I would like to ask, Mr. Chairman, that these accounts, which include Otter Creek Associates, Bi-Coast Investment Associates, Capital Fund, Concordia Investment Associates, and a number of others, be admitted into the record at this time.
Without objection, so ordered. Gentleman from Oregon.
Mr. Chairman, I would only make one other point at this time, and that is that I think it's going to be particularly important to this committee's inquiry to learn where the SEC was, the Securities and Exchange Commission, during the course of the trading by these Drexel Burnham employees in their own accounts. The old saying is, curious people want to know. I'm particularly anxious because I think there are many issues that have to be examined with respect to these accounts, how an employee comes to participate, whether they're allowed to participate in deals that they've put together, and I'm particularly anxious to learn where the Securities and Exchange Commission was during the course of the trades that were done by the Drexel Burnham employees. I look forward to our inquiry, Mr. Chairman, and commend you.
Chair, thanks, gentlemen. Were there further statements at this time? Distinguished gentleman from New York, Mr. Light.
Mr. Chairman, I have an opening statement. Thank you, Mr. Chairman. Today, the subcommittee will examine a number of Drexel Burnham Lambert's activities in the high-yield bond market. Drexel is the single largest underwriter and market maker of high-yield bonds. Drexel, along with other firms, have created a trillion-dollar securities market. The corporations issuing these junk bonds use them for traditional corporate activities, such as building factories, hiring workers, and other similar purposes. But today we are looking at several Drexel-managed offerings of securities that raise important legal and policy issues. Two of these offerings involve sales of a substantial portion of the securities to accounts owned by partnerships composed of Drexel employees. I believe that we should examine these offerings in careful detail. We need to consider whether these sales are consistent with the letter and the spirit of the securities laws, and if they are, we should consider whether our laws need to be strengthened. Moreover, we need to evaluate the appearances that these practices create. Some argue that because the underwritings we are scrutinizing involve debt, it is simply irrelevant as to whether employee insider accounts purchase the securities. According to this view, the purchases of these offerings are buying an essentially fungible commodity. In other words, one double B-rated bond paying a specific rate of interest for a specific term is no different from another. Trying to distinguish one such bond from another is like trying to distinguish 2 bushels of wheat of the same grade. But there is another side of this argument. Some say that selling high-yield bonds to employee insider accounts is a modern version of a classic market manipulation. That scheme involves selling securities to employee insider accounts to create an artificial scarcity and raise the price. The employee insider accounts sell out their shares after the price goes up and leave the remaining investors holding the bag. We need to sort out these conflicting views today and gain a better understanding of the economic forces at work. But our inquiry should also go beyond the technicalities of complex economics and regulation. The securities markets runs on a fuel more precious than money. They run on public confidence. Individual households own more than 60% of the publicly held securities in the United States. When you add pension funds and mutual funds, we reach a figure of over $3 trillion. It is obvious that investor confidence is critical to ensure the continued depth and liquidity of our markets. We need to ask whether allowing affiliated investors, insider employees, to purchase securities in a debt offering ahead of other investors is a nefarious practice that should be banned, or whether it is harmless. I will inquire of the witness whether Drexel's regular customers who may have been denied access to some of these bonds were made aware of the so-called insider accounts or employee accounts, and whether Drexel would want them to know of their existence. I hope that today's hearing will afford us new insight into these matters. In addition, I intend to make inquiries into transactions involving Home Shopping Network's allegations against Drexel. This inquiry may shed additional light on certain practices that may be objectionable. The point of today's hearings is not to reach any final conclusions or to act as a court of law. Our objective is to ascertain whether our capital markets and our securities laws are operating in the best interest of investors, our economy, and the public. Thank you, Mr. Chairman.
Chair, thanks, gentlemen. Were there further opening statements at this time?
Mr. Chairman.
The gentleman from Kansas, Mr. Slattery.
Mr. Chairman, I too would like to commend the chairman for holding these hearings, and as the committee of the Congress that has primary oversight responsibility for the securities industry, I believe that this committee has a fundamental responsibility to monitor as closely as our resources permit the operation of the U.S. securities industry. The much publicized scandals on Wall Street over the last few years, the events of October the 19th, 1987, and subsequent events and the volatility of the stock market make this responsibility even more urgent. And Mr. Chairman, I am particularly interested in the operation of what is called employee accounts and the way they handled initial public offerings inside Drexel Burnham. And in particular, I'm concerned about the BCI transaction, which involves the leveraged buyout of Beatrice companies. And in particular, Mr. Chairman, United High Income, which is a part of the United Group of mutual funds based in Kansas City, Missouri, which has more than 580,000 shareholders, is a company that was involved in this transaction, and I'll be curious to hear the response to the questions that I have about whether those shareholders of of United High Income were denied access to the market at a very important time. So, Mr. Chairman, again, I commend you for calling these hearings, and Mr. Joseph, we welcome you, and we will do everything we can to make sure that you are given adequate opportunity to respond to our questions, and we'll treat you as fairly as possible. Good to see you.
An opening statement.
The gentleman from Florida.
Very brief opening statement.
Recognized for an opening statement.
Mr. Chairman, I too commend you for holding this follow-up hearing. I quite often ask at the outset that we be open-minded and objective, and since these are information-gathering sessions, the only way we can actually gather information in an objective manner is to be open-minded, and I am satisfied, of course, that this committee will be so. But I am concerned about credibility and lack of confidence in the marketplace with investors. I think it's just critical that this hearing and this series of hearings is going to go a long way towards that. It's either going to raise the confidence level of American investors in not only in Drexel but in our investment community. I haven't gone back into history as to why Wall Street was designed in the first place, but I suspect a very principal reason was to raise capital for American business, which in turn employs people, and consequently it's very critical that we Americans retain our confidence and credibility level in the capital markets. Thank you, Mr. Chairman.
Chair thanks the gentleman.
Mr. Chairman.
Gentleman from Minnesota, Mr. Sikorsky.
Mr. Chairman, thank you. I too add my Midwestern and flat tenor or bass voice to the chorus of commendations to you and the staff for this ongoing effort to examine our securities markets. Today, I, like other members, will be focusing on a junk bond issue. The one I will be focusing on was for Textyrene, Inc., underwritten by Drexel Burnham. I will ask if clients dominated by Drexel employees got a better deal than public clients of Drexel, to whom the firm owned a fiduciary duty. I'm especially interested to determine if two major Minnesota investors, IDS Inc. and Lutheran Brotherhood Life Insurance, were disadvantaged. Again, Mr. Chairman, you should be commended.
Chair thanks the gentleman. Were there further opening statements? Chair hears none. Mr. Joseph, it has been the practice of this committee since it was first created by Sam Rayburn in 1958 to insist that all witnesses appearing before the committee be sworn. Do you have any objection being sworn?
No, I do not.
The chair notes that you were accompanied by an associate who I believe is willing to be sworn and testify today. That is you, is that correct, Mr. Schneiderman?
Yes, Mr. Chairman. My name is Erwin Schneiderman. I'm a lawyer in the firm of Cahill, Gordon, and Rindell in New York. We are counsel to Drexel, but I am here as a securities lawyer, having practiced securities law for quite a period of time, and would be happy to be sworn if the chairman so requires.
Well, it is not the prerogative of the chair to tell you whether you appear here as counsel or whether you appear here as a witness. The option is entirely yours, and the chair will leave the choice to you as the chair must properly do. If you wish to participate as counsel, that is your right, and it will be carefully respected by the committee. If you appear here as a witness, you will appear here in a different fashion and capacity. Clearly, if you were here as counsel, you will not be sworn. Clearly, if you are here as a witness, you must be sworn. And with all respect, the chair must leave that judgment to you.
Well, I was wondering, Mr. Chairman, whether we can ride both horses. I would be happy to be sworn when legal questions arise. I would like, however, in the course of the hearing to be able to confer with Mr. Joseph as questions are asked by the committee.
The chair has got to observe, for the benefit of us both, before we commence, that the chair cannot permit you to wear two hats. We permit you to choose the hat that you wear, but we cannot dictate that to you. But the choice must be yours, and the rules of the committee and the rules of the House dictating the behavior of witnesses or dictating the behavior of counsels will have to be applied fairly to you. And that is the reason for this dialogue, so that you understand and we understand, and so that there's no distress later on as we proceed.
Well, Mr. Chairman, I don't want to mislead anybody. I'm not a law school professor. I'm a practicing lawyer, having practiced securities law for a long, long time now, and I've been working with Drexel on this matter. So I don't want to mislead you in describing who I am. I just question if I am sworn and answer legal questions, will it be permissible?
If you are sworn and you are asked a legal question, you will be expected and have every right to respond in the appropriate fashion. And I want that very clear. We will not intrude into your proper answer. But the chair is going to observe you don't need to be a law school professor. A skilled practitioner of law like yourself keenly understands these differences, and your modesty becomes you, but it exceeds the needs of the committee. I gather you have not yet exercised your judgment here, and if you wish to advise Mr. Joseph, we will permit that, but you will advise him as counsel. In that event, you will not be sworn. If you wish to testify, you must be sworn, and you may not advise Mr. Joseph on points of law. I gather he has other counsel here for that purpose anyway. The choice, Mr. Schneiderman, is yours.
You're not going to ask him that? Do you waive the attorney-client privilege?
Well, I'm going to ask that.
Yeah.
I'm very happy to be sworn, Mr. Chairman.
All right, if you'll take your seat for just a second, I don't want you to rush into this thing. The chair does have to advise you so that you are aware, and so that in no way are you led into traps by this committee, that if you are sworn, you do waive attorney-client privilege. And that will definitely be the case as regards this proceedings. It may also be the case as regard to subsequent proceedings.
Well, Mr. Chairman, I'm not sure that I understand the full import of that.
Well, I'm not sure I do either, Mr. Schneiderman, so we both approach this with some ignorance.
I would expect to be asked legal questions about interpretations of NASD and SEC rules. I would not expect to be asked what legal advice I have given Drexel Burnham in the course of my representation. If I waive that by being sworn, I think I've got a big problem.
Well, as a matter of fact, the reason I raise it is so that you will not blunder into any thickets for which you are unprepared.
Well, Mr. Chairman,
witnesses who do appear here before this committee do appear here as regards all matters. Now, the chair is not anxious to rule on questions of waiver, and I warn you so that you will not be in the awkward position And I won't be in the awkward position of having to address this question.
Well, Mr. Chairman, I guess it would be less helpful to the committee if there is no expert on the securities laws here to testify today. And it may be that a resolution of it is, as these legal questions develop, we would request the opportunity to make a submission to the committee with respect to the legal points that are raised. We had.
I have a feeling that that may be the best question, and the chair, in the interest of fairness, will inform you that if you feel that there is need for the committee to have your testimony, or if Mr. Joseph feels the need for that, we will do our best to see to it that at the appropriate point we address the question, and we would hope that you and Mr. Joseph then would raise it so that we can deal with it. I'm anxious to be fair to you, and I want you to understand
well, thank you, Mr. Chairman. I appreciate
the implications of this matter.
I take it that what you're saying is if a legal question arises and Mr. Joseph needs to refer to me, we'll take it on a case-by-case basis rather than being sworn in advance on all issues.
Yes, I would think so. I've never dealt with this. We have simply insisted that everybody who testifies before the committee is sworn. That they did that when Orrin Harris was chairman.
I hope it doesn't become the practice that lawyers have to be sworn before they give their opinions. It's a very dangerous precedent.
I'm sure you're a good enough character that swearing you is not going to alter the truth or falsity in any particular.
Not at all.
I will observe there are certain members of the practice, and I happen to be a lawyer, who I think wouldn't be benefited, but for different reasons. I'm not sure they're too honest in some ways. It must be observed, and I have to say this for your benefit as well as that of the committee. Facts which you have learned in the course of your attorney-client privilege might be matters which would be inquired into. And I don't want you to be in a position of being unaware of that peril being over you or over the committee.
Well, may I consult with my counsel, if you please, Mr. Chairman?
Of course.
Strange they haven't thought of this.
People focus on things. And the committee is not. I'm sorry, Mr. Schneiderman, go ahead.
Mr. Chairman, my counsel has advised me that I would prefer not to be sworn, that we would not want to incur the risk of waiving the attorney-client privilege. However, in the course of the hearing, I'll be as helpful as I can, and indeed, after the hearing, would be happy to make a submission to this committee on the legal issues as they arise.
We'll be happy to receive that at a later time. I would think that in fairness to you, and it ill behooves me to advise you, I understand that, but your purposes, and I think the purposes of the committee, would be best served by not having you sworn and not having you testify. The chair will observe that the function of counsel, and I'm sure that both you and Mr. Joseph and Mr. Fleming are aware of this, is to advise the client before a congressional committee of his rights and not to not to testify. So we will proceed with that tradition and with the long-established practices of this committee and under its rules in that fashion. Mr. Joseph, is this agreeable to you, sir?
Yes, it is.
Very good. I notice you're accompanied by Mr. Fleming. Mr. Fleming, you appear here as counsel to Mr. Joseph this morning.
Mr. Chairman, I am counsel for Drexel Burnham, and in that capacity I'm appearing for Mr. Joseph in his capacity as Chief Executive Officer of Drexel Burnham.
So you're appearing here then as counsel to Mr. Joseph, and your function will be to advise him as he appears here. Well, Chair has no objection to you and Mr. Schneiderman, if it be the wish of Mr. Joseph, both appearing here as counsel and advising Mr. Joseph, and we will see to it that if that be your wish, Mr. Joseph, it will be handled in that particular fashion. Gentlemen, the second item of necessary business of this committee is for me to observe that for each of you there are copies of the rules of the subcommittee, rules of the committee, rules of the House, there in the red and the beige books which you have in your hands. The purpose of those documents is to inform you of the limitations of the powers on the committee and the limitations of the powers of the subcommittee. It also is to inform you of your rights so that you may proceed with full information as to the situation in which we are today. Then, if you have no objection to being sworn, Mr. Joseph, will you please rise and raise your right hand? You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Joseph, you may now consider yourself to be under oath, and the Chair will recognize you for your opening statement.
Thank you, Mr. Chairman. I've noted this morning that seems to be a tradition at this committee in mentioning where your voice is from. I'd like to point out my voice today is from having a cold, and would like your forbearance if it fades on me. Mr. Chairman, our firm has approached the work of this subcommittee in good faith, and I appear here this morning voluntarily. As you know, our cooperation with the members and staff has extended over a period of months, involving submissions of thousands of pages of documents, as well as a tremendous number of man-hours. We have tried to be completely open, within, of course, the limitations imposed by ongoing federal investigations, of which the subcommittee is well aware. Our openness, with all its attendant time and expense, is motivated by a simple purpose. We feel that a dispassionate and knowledgeable examination of the facts will help restore public confidence in areas where questions have been raised. Public confidence in the integrity of our firm is the most important factor in every decision I make as Chief Executive Officer of Drexel Burnham. I hope today to foster a clearer understanding of high-yield debt, how the market for high-yield debt functions, and how these bonds benefit our country and its economy. Before addressing these important matters, let me give you a brief overview of Drexel Burnham. Drexel handled over $3 trillion of transactions last year for ourselves and for clients through some 4 million individual transactions. The firm carries a $30 to $40 billion position of total assets and has a capital base of $2.2 billion. Over 75% of the firm is owned by 2,200 officer employees. Ownership itself is broadly spread among our people. We estimate that for 80% of the employee shareholders, more than 80% of their individual net worth is tied up in the equity of the firm. Drexel is not just a high-yield firm. The fact is that less than 10% of our revenues and only 300 of our 10,300 employees are actively involved in researching, marketing, and trading high-yield securities. Drexel is among the top 5 firms in institutional sales, equity research, commodities trading, government bond trading, high-grade corporate bond trading, merger and acquisition advisory work, private placements, and public offerings for industrial companies. Drexel Burnham is, of course, a major participant in the high-yield market, which has been developed and has developed into the primary source of long-term financing for small and medium-sized companies. Without high-yield bonds, some 1,200 issuers might not otherwise have been able to obtain the long-term capital essential to their economic growth. The advent of the new issue high-yield bond market provided their first access to the long-term public fixed-rate debt market. Today, there are $160 billion of high-yield bonds outstanding. That capital has primarily been used by companies to expand and grow their businesses, build new plants, and create job opportunities for millions of Americans during the 1980s. High-yield bonds are no different from any other fixed-income security, except that they carry below investment-grade ratings, often merely because of the issuer's size or lack of credit history. As you may know, only 800 companies in the United States have an investment-grade rating. All other corporate issuers would be high-yield issuers. The high-yield bond market has attracted professional institutional investors among mutual funds, life insurance companies, thrifts, pension funds, corporations, and contrary to the general perception, only relatively few individual investors. Because diversification and sophisticated credit analysis are essential to participate in this market, we believe that most retail customers should only invest in high-yield debt through mutual funds. There are now 81 high-yield mutual funds with over $27 billion under professional management. I believe it is critical that the subcommittee understand the significant difference in the way debt issues are priced and underwritten as compared to equity issues. Unlike equities, which are in large part are priced based on expectations as to future earnings, growth, and dividends, bonds represent a contract between an issuer and the investor to provide a specific yield or a specific return over a stated period of time and at maturity to be redeemed. Accordingly, bonds are priced based on their yield, typically as related to interest rates at that time for comparable securities, as well as the perceived creditworthiness of the issuer. Another difference between debt and equity is that for an investor to realize on equity, he usually must sell into the market. To realize on a debt instrument, he merely needs to hold the instrument until maturity. After adjusting for creditworthiness, debt securities are essentially fungible. For these reasons, it is very important for the subcommittee to recognize that a new debt issue cannot be considered a hot issue. Moreover, we believe the law recognizes this distinction in that the hot issue rules do not apply to debt offerings. The high-yield market is highly competitive. Institutional participants typically employ in-house traders and research analysts to help and advise portfolio managers. Moreover, it is a highly liquid dealer market. Each of the 10 largest firms in the securities business, a group with capital aggregating $28 billion, today trade these securities, make markets in high-yield bonds, and underwrite them as well. Like the investment-grade bond market, most trades in the high-yield sector are handled over-the-counter, the oldest securities market in the United States. The U.S. capital markets provide the most efficient means of capital formation in the world. The debt markets, in particular the high-yield market, do not exist in any similar magnitude or efficient mode anywhere else. There is a mistaken belief that high-yield bonds are necessarily of low credit quality. This is not true, since some of the best-performing companies in America are, in fact, high-yield bond issuers. Of the 22,000 companies with $35 million or more in sales who may qualify to issue high-yield bonds, to issue public bonds, only 800 are rated investment grade. All other companies, including many household names, were they to issue a public bond, would earn the pejorative term junk bonds. The high-yield market has proven itself to be important in allowing companies to grow, to create jobs, and to keep this country competitive. And any suggestion that it does not work does a vast disservice, which could well have adverse consequences for our economy. High-yield bonds should not be thought of as synonymous with hostile tender offers. Only 6% of the high-yield bonds underwritten or placed by Drexel since 1980 were utilized for hostile takeovers. Most financing for hostile takeovers is provided by banks and insurance companies or internal corporate cash. I would now like to talk briefly about Drexel Burnham employee partnerships. These, unfortunately, have been referred to as, quote, insider accounts, close quotes. They are simply employee investment accounts. As with any investment by a single employee, these partnerships are subject to the same compliance monitoring at the firm as are all other employee accounts. We believe combining capital through these partnerships is a preferred method for employee investments. By having a partnership in which decisions are made by a management committee or managing partner, employees are able to rely upon people they have confidence in to manage their investments. This enables them to concentrate on their respective duties at Drexel Burnham, as opposed to having the employees worrying about their personal investments during the workday. Moreover, the partnership vehicle permits the accumulation of sufficient capital to acquire a diversified portfolio of high-yield debt, which diversification is needed to maximize the benefits and minimize the risks of holding such securities. The partnerships invest in securities through employee-coded accounts established at Drexel. Activity in these accounts is reviewed daily by the Legal and Compliance Department. In addition to the compliance system, we have other internal procedures pursuant to which we approve the securities transactions between employee accounts and the firm. I am not aware of any problems concerning trading by partnership accounts in high-yield bonds. That these partnerships invest in high-yield bonds is consistent with our faith in the high-yield market. The fact that our employees have seen fit to invest and risk their own money in this market is not to be condemned. These partnerships participate in offerings on the same basis as other investors. Let me also stress that these partnerships simply are not a significant factor in either the original or secondary market. Finally, Mr. Chairman, I'd like to close on a personal note. The last 17 months have been difficult. No securities firm has ever had to endure the kind of intensive investigation now underway by the torrent of adverse publicity which we have experienced. Throughout this period, the firm has continued to play a significant and positive role in the financial system. Our ability to accomplish this has been a function of the hard work of our employees and the confidence placed in Drexel Burnham by its clients. I believe that ultimately this confidence will be justified, and the important role that Drexel Burnham has played in our increasingly complex international financial system will be recognized. Thank you.
Mr. Joseph, the committee thanks you for your very helpful statement. The Chair has several essential housekeeping matters to deal with. First, the Chair would observe that the staff has requested account statements for the Otter Creek Associates. Those have not been made available. The staff has also requested the account statements for Concordia Investments and for Financial Investment Associates, showing their investments for the years 1983 and 1984. Would you please make those available to the committee?
Yes, we will, as soon as we can.
Very well. Mr. Joseph, in your comments...
Excuse me, Mr. Chairman.
I'm sorry.
I'm sorry.
Certainly.
Tom? Address the Chair.
You mandate?
Mr. Chairman, the requests for the Otter Creek statements and for the statements in question were for the years 1985 and 1986. It is my understanding that they have been produced to the staff.
The chair is not aware of that. I have asked for 83 and 84. The staff has asked for 83 and 84. I'm told that those have not yet been made available. Would you please check that out? The chair has advised that the staff has been told that these documents were coming, but the chair checked this morning, and the chair was advised that they had not yet been received.
I have the question, Mr. Chairman. Thank you. I'm confident that 85 and 86 have been produced. I will check on the others.
If you please. Mr. Joseph, there's been some criticism of the committee for using, in connection with its proceedings, the words, quote, insider account, close quote. You are aware of the fact that in the Holman case, that term was used to refer to accounts of persons who functioned as employees of and inside of a particular firm. Are you not?
No, I am not.
Well, it happens to be the fact. Were you aware of the fact that the SEC in its terms, referring to similar activities inside firms, has used the term insider account in connection with a 1959 SEC release, which set the original and initial rules and restrictions on such activities.
No, Mr. Chairman, I wasn't. I think the reason we were objecting is I think perhaps the word insider has taken on new pejorative meaning because of insider trading. And as a practical matter, these really are simply accounts of employees at the securities firm. But I was not aware that that was a term that had some history to it.
Well, I want it understood that these are not used in the pejorative fashion by the committee, and they do not reflect on one way or another upon the activities of yourself or of Drexel Burnham Lambert or any other person or any of their employees. It's simply, the committee is simply using words of art which are well understood and which have been in existence for some time and which are essentially imposed upon both you and I by both the SEC and the courts. So I want you to understand that we are not taking advantage of you in this particular.
I understand. Thank you.
You see about the light. Find out what's wrong with the light down there. Mr. Joseph, the committee has some questions now. I will begin and then recognize my colleagues in appropriate order. Would you describe why these bonds are called high yield, referring to the high yield bonds or the high risk or the junk bonds?
Yes, sir. The most accurate way to describe these bonds is that they are bonds that have been rated less than investment grade by the rating agencies. The rating agencies historically look at size as a very important consideration in trying to determine credit quality. Historic numbers are looked at more importantly than perhaps the future numbers. And as a result, smaller companies, growing companies, more highly leveraged companies would typically not have an investment grade rating. In trying to find a name to use in the market, less than investment grade is a mouthful, and since the lower rated issues typically must carry a higher yield, we came to use that term, the term high yield, to describe the less than investment grade world of corporate bonds, public corporate bonds.
Mr. Joseph, in many cases, takeover targets will issue junk bonds to retire the interim or bridge financing of the takeover. What then happens in situations where already outstanding bonds have been issued by the target company? They are downgraded, are they not?
That will depend on the relative seniority of the target company's debt as opposed to the acquiring company's debt, whether they're retired or not retired. There have been occasions where the target company's debt has been downgraded in recent years. Yes, sir.
Now, when these bonds are in fact downgraded, the original investors then lose significant amounts of their investment, do they not?
They don't lose significant amounts of their investment in that the credit is virtually always still of sufficient quality that the bonds will be paid off. However, the market value of the bonds will decline if there is a downgrading in most cases.
So the market price goes down, but the face value remains the same, and if the individual in question holds that bond for the duration of the time, he gets his full investment back.
That's correct.
According to its terms. Very well. Do the original investors in these bonds have any say for or against the takeover?
They usually do not have a vote. There may, however, be covenants in that issue which will preclude the acquiring company from proceeding with the transaction without in some way accommodating those bondholders, obtaining their consent in one form or another. There have also been occasions where the acquiring company and the acquired company on a friendly transaction have voluntarily raised the interest rate to the existing bondholders to help compensate them for the fact that the capital structure of the company is changing.
That is not a common event, however.
It has happened several times in recent years.
But it is uncommon in the total percentage.
It does not happen in the majority of the cases.
Stockholders, however, gain by the increased market prices in the takeover processes, do they not?
Yes, they do.
As a general rule, at least. And the bondholder has little say in the rejection or the acceptance of the takeover, but the shareholder does. Is that correct?
That is correct. Typically, the contract is that the shareholders are the residual risk takers in the companies. They are the owners. And the bondholders have, in fact, have a contract with the company to lend the money with terms. Now, these bondholders are sophisticated institutional investors. In many of the issues we do, we put in restrictive covenants protecting the net worth base of the company, which effectively would preclude a highly leveraged buyout, for example, without the approval of the bondholders. And very often, on the original issuance of those bonds, the extent to which the bondholders are protected by covenants will affect the price. So effectively, the arrangement has been negotiated by the institutional investors with the underwriters in the middle and the company on the other hand at the time of the original issuance.
Mr. Joseph, the chair is curious. The bondholder here, at least the original bondholder, appears to have rights which are somewhat deficient as when compared to both the holder of subsequent issues of high-interest bonds or junk bonds, and also as regards to stockholders. Should there be some action taken to afford additional protection to bondholders under these circumstances so that their values and the value of their assets and investment would not be depreciated, or they would have greater say in the events that are affecting them?
I think not, Mr. Chairman. The corporate bond market in this country is about a $600 to $700 billion market. The participants are all professionals with good, solid professional staffs, including legal advice. And the nature of the bond is it's a negotiated contract. And, you know, whether they want to have better redemption terms or looser redemption terms, whether they want to have strong restrictive covenants or are willing to proceed without restrictive covenants, whether they're willing to give up restrictive covenants in exchange for having the marketability, the right to sell the bonds in the market as compared to a private placement which has much more restrictive covenants, are all items that the institutional investors should be, and I think generally are well aware of. So I think you're talking about a negotiated market between sophisticated professionals, and occasionally you're unable to anticipate future developments, and one part or the other may have gotten the better part of the contract, but I don't see any reason for the need for there to be legislative help to these professionals. They're sophisticated, they know what they're doing, they know what covenants they did insist on or did not insist on, and it usually is reflected in the price.
Thank you. Chair notes the time of the chair has expired. Chair will recognize next the gentleman from Virginia, Mr. Bliley, for questions.
Thank you, Mr. Chairman. Mr. Joseph, did Drexel actually invent the high-yield bond market?
No, sir, we did not. The origination of the high-yield bond market since the 60s really evolved through the downgrading of issues, public issues, which had originally been issued as investment-grade debt. If you go way back into the early 1900s, there were issues by young companies of public bonds which would not have obtained an investment-grade rating. The original bond issues of General Motors, IBM, U.S. Steel were at the time of issuance junk bonds, using the pejorative term, or high-yield bonds, less than investment-grade quality credits. The new issuance of high-yield bonds dried up as we came through the Second World War and 60s, 50s, 60s, 70s. And beginning in 1977, new public issues of high-yield bonds commenced. Drexel did not do the first 3 or 4 of those issues. They were done by other firms. We were an active participant in the aftermarket and realized that we could help some of our emerging, growing corporate finance clients raise capital by issuing newly issued, long-term, fixed-rate, high-yield bonds. And by the end of that year, we were the number 2 ranked underwriter and have been the number 1 ranked underwriter since then. But the original term junk bonds actually came from the fact that the bonds that were trading in the early 70s in the high-yield market were deeply discounted bonds of companies that had generally fallen on hard times. REIT, some of the railroad bonds, other companies, what we now call the fallen angels.
Edge of the high-yield bonds sold in the United States today are handled by Drexel?
It varies with the market conditions. We tend to do a larger market share when the bond market is having a difficult time absorbing new issues because yields are rising and bond prices are falling, so that our market share has occasionally gotten as high as 60, 65%. When it's extremely difficult for companies to raise money, our distribution strengths have been especially helpful. When it's relatively easy for companies to raise money in the high-yield market, our share of the new issue market has declined to in the upper 30%, 40% range.
How do you, as Drexel, solicit corporations that would benefit from issues of high-yield bonds?
Excuse me, I'm not sure.
How do you solicit business from corporations that would benefit from issues of high-yield bonds?
Well, we typically will do computer screens of companies, understanding which parameters might indicate a company could need additional permanent long-term capital. You might find a company that has what appears to be a disproportionate share of their capital structure in floating rate short-term bank debt. And of course, as we learned in the early 80s, when interest rates on short-term debt spiked up to 21%, that can be very harmful to a company. So if we think a company has too much short-term debt, we may visit with them, send our corporate finance people to see them, and tell them they can refund some of that bank debt with long-term fixed-rate debt, and then operate with the knowledge that they know what their interest costs on that portion of their capital structure will be. We also sometimes do industry solicitations. We decided in the late 70s that the cable industry suited itself to high-yield bond issuances. These companies had spent a lot of money constructing their plants, their cable plants. They typically had very low net worth, very high leverage, and their earnings were not very good at that stage. But we felt that they had a lot of the characteristics from an investment point of view of a utility, predictable future cash flows. So we solicited the cable companies and ended up being the dominant source of permanent capital to the cable industry, which has been very successful for us as an investment banker, for the institutional investors, and provided a tremendous amount, billions of dollars of fixed-rate long-term capital to the cable industry.
Reach agreements with those companies to underwrite the securities?
Well, at the initial stages, they very often will talk to us, and unfortunately, from my point of view, a number of other investment banks decide on which type of financing they want to use. There are typically competitive ideas, maybe doing a Eurobond offering or an equity or a convertible debt or a private placement or bank debt. Once they're persuaded they want to do a high-yield bond issue, again, we very often will have competition from other firms who also underwrite high-yield debt issues. We think we can establish that we have an excellent position in that market as an issuer and underwriter and trader of high-yield issues. If we obtain the order, you then do your due diligence, write a registration statement, and then take the company out on what is called a roadshow to meet the professional institutional investor community, who are the people that buy the high-yield bonds. And then at the point of the actual pricing, the pricing is negotiated by the company and Drexel Burnham with the corporate finance people who really view the corporate issuer as their client, obtaining input from several sources within the firm, the sales department, the high-yield bond salespeople. They will talk to the syndicate department to see what other firms think the bond should be going at. They will look at the order book of the sales departments to see if any of the institutions have given us limit orders, i.e., I will buy these bonds, but not unless they yield at least 13%. And someone else may say not unless they yield at least 13 1/8, and we can see where the orders are and decide what price is the right price. They also will obtain information on the current market conditions from the traders, and ultimately, the fact is that the determination of the price of a high-yield bond is really determined by the relative credit quality of that issuer in the continuum of all the high-yield issuers. There are now 1,300 of them, and as you look at them, you can tell that this particular credit is better than number 120, but not quite as good as number 125, and maybe almost exactly as good as 122. And the range between the bid and ask, if you will, on what the appropriate interest rate should be on that loan for 20 years is very seldom more than 1/8%, which on a 20-year loan is about a 1% differential in price. So it's negotiated by our professionals using a lot of statistical analysis and market information with the chief financial officer, very often the chief executive officer of the company, and their staffs, who today are often very sophisticated also.
Thank you. I see my time has expired, Mr. Chairman. Thank you very much.
Time of the gentleman has expired. The chair recognizes the gentleman from Oregon. At this time, Mr. White.
Thank you very much, Mr. Chairman. Mr. Joseph, good morning. I think you heard in my opening statement that I put into the record an index of 33 insider accounts that I've obtained, and I would like to ask you about a number of them specifically. Let us begin, if we might, by having you tell us what the Otter Creek account is, and particularly how it operates.
Well, I have been advised that Otter Creek is an account which I believe is made up of members. It is a partnership, I think, and I think its investors are members of the high-yield bond department. As I understand it, it has an investment committee and invests primarily in high-yield bonds.
When did this account, when was it established?
I don't know, actually. My guess would be in the late 70s or early 80s.
And when did you first learn about it?
Around the time when I think it was established, probably more likely in the early 80s.
Do you know if the account at any time purchased securities in which Drexel was an underwriter or marketer on terms more favorable than other clients of Drexel received?
No, I don't think so. Typically, these underwritings are fixed-price underwritings, and I would expect that the partnership would be purchasing newly underwritten securities on the same terms as other institutional investors, if they purchase it on the offering.
How did you first learn about the Otter Creek account? I thought I heard you say in your answer to a previous question you first heard about it. You first heard about it at the time it was started.
No, I'm not sure I heard about it at the time it was started. I don't recall. It's quite a number of years ago. I don't recall how I first heard of it. It was in existence, I think, when I first heard about it.
What did you learn about it at the time?
What did you learn about it at that time?
Well, at that time, I was the head of the corporate finance department, and someone must have told me that the members of the high-yield bond department had pooled their investment funds into a partnership and were making investments.
But how did it come up? You said someone told you about it.
I don't recall.
Has it ever come up since?
Since that time, has it come up at Drexel Burnham?
Excuse me?
Since that time, since the time after you first heard about it, was it ever discussed at Drexel Burnham?
Yes, it has been discussed since then.
Were the investments discussed?
Were the investments that were made by the account discussed at Drexel Burnham?
Yes.
What are you privy to discuss?
Could you tell us if you were privy to those discussions about those investments?
Generally, I would not be privy to discussions about the investments of Otter Creek. From time to time, as the head of corporate finance, I would be.
Well, describe specifically then the investments that you knew about by Otter Creek.
This was quite some time ago, and I'm not sure I can recall the specific investments I knew about that I knew they were making. Perhaps it'd be helpful if I explained the roles and why I was not aware and what I was aware of, because I think...
Well, I want to know, though, before we get into that generally, about the information you specifically knew about investments at Otter Creek.
I generally was not aware of Otter Creek's investments.
But specifically, were you aware of any information about investments made by Otter Creek?
Congressman Wyden, what I'm trying to recall the best I can is the fact that I did become generally aware of Otter Creek. My guess, and I really don't recall, is that they probably were buying some issues where the corporate finance department had an interest because it was an issue of a client, and I was told that they had bought bonds in a client, or they were going to buy bonds in a client company. I do not remember which companies, and I don't remember the specifics of those conversations. This was probably 8 to 10 years ago.
Were questions raised at any point to your knowledge about the propriety of Otter Creek investments?
Not that I recall.
What other officers were aware of investments made by Otter Creek?
Well, I've been advised that the appropriate senior officers of the firm were aware at the time Otter Creek was formed that Otter Creek was being formed and what its purposes were. And then Otter Creek is, as an employee account, is coded as an employee account so that Otter Creek's investments are reviewed by our compliance department along with all employee accounts very carefully.
My time has expired, but I want to just finish this. Were there procedures in effect to ensure that Otter Creek did not get an advantage over Drexel's outside clients? And if so, how were they applied in this case?
There were procedures in place to be sure that Otter Creek did not get an advantage over outside clients, just as all employee accounts are watched so that they do not get an advantage over outside accounts. The procedures effectively occur at 2 levels.
Were those procedures in writing?
Yes, I believe they are in writing.
Would you submit those for the record?
I will. These are our general compliance review procedures, which we will submit.
Please submit.
Let me, if I may, finish answering the question. So that at the compliance department, the professionals in that department would be reviewing these accounts against a whole list of rules and regulations that apply only to employee accounts. Furthermore, the senior officers of our firm review the high-yield bond trading departments. The head of the trading department is a vice chairman, and in fact, the chairman of our firm has a practice of reviewing the trades in the high-yield bond department, and they both would have seen Otter Creek and would be aware that Otter Creek was an employee account and have been able to, from a business point of view, review Otter Creek's investments.
Time of the gentleman has expired. Mr. Joseph, would you submit those papers referred to by Mr. Wyden to the committee with appropriate notations as to the portions which relate to controls of the behavior either of Otter Creek or any of the other investment clubs which exist inside the offices of Drexel, Burnham, Lambert, which involve their offices?
Yes, I will, Mr. Chairman. I'd like to point out that these procedures I'm talking about are procedures that apply to all employee coded accounts, and they apply to the Otter Creek or any other...
Or any of the others?
Any of the others.
There were, I believe, some 35?
I'm not sure of the number, but
33, Mr. Chairman, is in the index that I put into the record this morning.
Very well. The chair now recognizes a distinguished gentleman from New York, Mr. Lane, for 5 minutes.
Thank you, Mr. Chairman. And Mr. Joseph, I think I heard you say during your opening statement that one of the reasons these employee insider accounts or employee investment accounts or whatever we want to call them, or clubs were set up was so that your employees would not have to be worrying about their investments during the workday. They should keep their mind free and clear. Can you tell us whether any senior employees of Drexel are involved in these clubs?
These clubs are investment partnerships.
I'm trying to determine what level of employee.
Yes, sir.
Were any general partners members of these clubs?
We are a corporation, so it gets a little more complicated than that, but I can answer your question. Let me do that. None of the senior line operating management of the firm have ever gone into any of these investment partnerships. A couple of the professionals in the corporate finance department that went into these partnerships while they were line investment bankers have been allowed to stay in the partnerships as they have moved up into relatively senior positions, so that of our, I think it's probably about a 16 or 18-man executive committee, 2 members of that committee, both of whom are line corporate finance professionals, are in the investment partnerships. None of the other senior management of the firm are in the partnerships.
Well, you said earlier that there was no question in your mind about the propriety of Otter Creek and these other clubs. Why then would gentlemen such as yourself or some of the other, there were only 2 members of the board that you said that were into these clubs, why would the others forego what appears to be a rather lucrative opportunity, and also one that would free up their mind for more important things?
From that point of view, I think it'd be a good idea, but at some level, someone has to supervise these activities. And it seemed to me when I was head of corporate finance that since I was going to be the ultimate decision maker on putting a specific investment into the partnership to make sure that there was no potential conflict of interest, because on the one hand, we knew there was a transaction going on that the fund managers didn't know about, and have them inadvertently stumble into something that would be perceived as a conflict of interest, that I was better positioned to make those judgments if I were not in the partnership. The other senior officers who are charged with reviewing the trades of those departments, for example, it was felt that they should not be in the partnerships that would be trading in those securities.
One of the transactions we are looking at is the junk bond underwriting for texstyrene. Are you generally familiar with that?
Yes, I am.
We note that Otter Creek bought $4 million of those bonds on February 11, 1986 at $982.50 a bond. Another one of the employee insider clubs, Concordia, bought $2 million on the same day, February 11, 1986 at $982.50. And in both cases, there was a sale just 17 days later at $1,065, throwing off a profit for Otter Creek of $330 and for Concordia of $330,000 and for Concordia $165,000. We also note that while these employee accounts were being paid $1,065, a smaller seller received only $1,010 for the same bonds. And I just wonder what explains the difference in prices on the same day. Rather substantial.
I'm sorry, Mr. Congressman, I'm not sure I know of a trade. I'm not aware of a trade at $1,010 on the same day that the partnership sold at $1,060.
Well, on February 28th, there is a buy by Drexel from a seller which is in our worksheets known as contra broker. Maybe that means something to you. Bought $3,000 at $1,010 a bond.
For 3,000
bonds.
Three bonds?
Oh, $3,000. This was a small investor at $1,010. All right, that one, we can check that out a little bit later. But on February 27th, Drexel purchased $1 million of the textyrene notes at $1,030 from a seller not affiliated with Drexel. But on the next day, February 28th, 3 of these Drexel employee accounts, Concordia, Otter Creek, and Financial Investments, received a substantially better price on sales to Drexel, namely $1,065. And I'm just asking what might account for the difference, and do you think this is a substantial difference?
I think I can account for the difference. First of all, the original purchases, which I believe were at $9,875 per bond, were made on the offering of there was a $50 million bond offering done that day. And that was on February 11th. On February 28th, when these partnerships sold out at $106.50, the U.S. government bond market during that period had moved even more than these bonds. These partnerships, had they invested in risk-free 20-year U.S. government bonds for exactly the same period, February 11th, February 28th, 1986, would have made about 1/3 more on their investment by buying risk-free government bonds. We were in the midst of this probably one of the strongest rallies in the fixed income market in history. And as I indicated earlier, these bonds are priced somewhat based on relative credit rankings and supply and demand on a spread above U.S. government bonds, which really set the base interest rate for long-term loans to anybody in this country, whether it's on a home or a car or to a company or a municipality. And when the tide rises, all the ships go up. So that move was more than accounted for just in the move in the government bond market. But besides that, in the high yield market, you do get moves in the bonds based on the underlying perception of the underlying equity value of the company. And we did a simultaneous offering of textyrene common stock, and the stock rose during that period a multiple of the amount that the bonds rose during the period.
Okay. Now, isn't there a general rule in your business that a broker should not make a bona fide, that a broker may not fail, quote, fail to make a bona fide public distribution at the public offering price of securities of a public offering which trade at a premium in the secondary market whenever such secondary market begins, unquote. That's an NASD rule. In other words, you're supposed to take care of your own customers and the public before your employees begin buying for their own account. Is that a article of faith in the securities industry?
There is a rule that you're describing. It's a National Association of Security Dealers, NASD rule. And that rule is talking about equity issues, hot issues where you're worrying about a substantial rise in the price. And
well, okay, that's an important point. You have said this before, that the hot issue rules do not apply to debt issues. They only apply to equities. And yet I'm reading from the rule here, and that's why I use the quotes. A broker may not, quote, fail to make a bona fide public distribution at the public offering price of securities of a public offering. It doesn't talk about equities or debt. It uses the word securities, which...
Mr. Schneiderman, the chair has to go back to our earlier discussions. Before we hear from you, we have to inquire, are you speaking now as a witness, or are you speaking as counsel, Mr. Joseph?
If permitted, I would like to speak as counsel, just to make an observation that had I been sworn and spoken as a witness, I would have spoken on this point. I would like...
Mr. Schneiderman,
I would like, however, Mr. Chairman...
With all respect to you, I have a feeling that at this time, given the circumstances under which we labor, silence is the best order for you.
I would just like to request the opportunity to make a submission to the committee on this point. I will not discuss it further.
Without objection, we will receive that and gratefully. Thank you, Mr. Schneiderman. Chair observes the time of the distinguished gentleman from New York has expired. The chair recognizes next the gentleman from Ohio, Mr. Eckert.
I thank the chairman. If I may inquire of my colleague from New York, Mr. Lant, is the chart you are working from the one entitled Textyrene Transactions that the committee staff prepared? I mean,
I'm working for a minority chart, and it may not be as...
May I ask, was this your chart prepared from our chart? I mean, I'm just trying to
we had to get this information with our own scratching and effort, as I understand it. Perhaps we would be better off if we would pool our resources on the two sides of the aisle.
I am only trying to inquire to make sure that we're all dealing with the same numbers. I mean, the numbers you all quoted are the same numbers that I have in front of me, and I just wanted to make sure we were working off the same numbers on this transaction. Mr. Chairman, I would just ask to make sure we're at least dealing off of this. I'm dealing off of this document. I would just ask unanimous consent that the chart labeled Textyrene Transactions be made part of the committee record here.
Without objection, so ordered.
Mr. Chairman, Mr. Joseph.
Mr. Chairman, may we have a copy of that, please, so we can follow it?
I don't have any objection to that.
It's in the book that was submitted to you, and the information that was submitted to you. The chair will ask the staff to see to it, though, that you have a copy so it is available to you.
Mr. Joseph, let me try to sharpen your memory on the question of who in the executive committee may be members of these accounts. You have stated, as I understand, that there are at least two senior members. The two members of the executive committee are members, but there were no other senior Drexel people as members. Can you reassert that for us?
I'm sorry, would you repeat the question?
How many members of the executive committee have memberships in these insider employee accounts?
I believe that two members of the executive committee have membership in these employee accounts.
Can you
I
identify?
have not, however, looked at a list of the memberships of these various partnerships myself, and it's possible there may be some others, but I only know of two off the top of my head.
Who are they? And who may those be, Mr. Joseph?
I'm sorry.
And who are those?
Those two are Mr. Batchelor and Mr. Kissick.
What about Mr. Gellert?
What about Mr. Michael Gellert?
That's the third one.
Are there others?
He is in some of the recent partnerships.
Are there others?
Not that I know of.
We have
senior Drexel people are members.
we have documents that you have provided us, which seems to indicate that there are 10 members of the Drexel board who have interest in at least one of the accounts that Mr. Wyden has provided for the record. We're going to have to reconcile your recollection and the list we have.
I'd like to do that. I should point out one difference which may not be obvious to you all, which is I'm talking about Drexel Burnham Lambert Inc.'s executive committee, which is the entity that, as a practical matter, runs what we call the firm. We do have a holding company called Drexel Burnham Lambert Group.
We're talking about Inc., not Group 2.
Okay. And Inc.'s board is a very broad group of people, probably 45-odd members. There are a number of them that would be in these partnerships.
But the Inc. board is the management board for Drexel Burnham Lambert.
No, it meets only once a year, and it is a relatively formal meeting. The Inc. board is not an accurate reflection of the management structure of our firm at all.
Would the gentleman yield the chair here?
Yes,
I think some housekeeping actions are in order on the part of the chair.
As long as the yielding does not come out of my time.
The chair will assure the gentleman that this will not be taken out of his time. Mr. Joseph, how many of these, and I want you to understand I'm using a word of art now, insider accounts are there at Drexel Burnham Lambert, and what are the names of them?
I cannot recite them, and I don't know the exact number, Mr. Chairman.
Would you submit that to the committee? At a time later, we will ask you to procure the assistance of your compliance director, who I understand is present in the room this morning.
Yes, we will.
Would you tell me whether there was any official requirement that they should submit, that members and officers and employees of the firm of Drexel Burnham Lambert, when they engaged in this kind of activity, that they procured any clearance, or that they submitted any information to Drexel Burnham Lambert with regard to these kinds of activities?
The answer is yes and no, Mr. Chairman.
Well, let's hear the yes first, and then let's go to the no.
Okay, it's easier. I think it's easy to understand if I do it the other way, but I'd be glad.
Well, let's hear the no first, and then let's hear the yes.
The no is that there are no specific rules with regard to investment partnerships that I'm aware of. However, the yes is that all investment partnerships that involve members of our firm must be coded as employee accounts. And we have very, very thorough rules on employee accounts. Employees are only allowed to have securities accounts at the firm unless they get very high-level exception, and we make virtually no exceptions. There are a couple, but we're very tough on it. We want them in the firm so that we can watch them on our computer compliance systems. And then, as employee-coded accounts, they're subject to the special scrutiny of the compliance department against a whole checklist of special survey and scrutiny criteria.
So Drexel did have these identified within its computer system?
Yes, sir.
These accounts. Would you submit to the committee the rules or other controls that Drexel had with regard to the behavior of either its employees and or the behavior of these employee accounts or insider accounts, with specific identification of those rules which would cover the behavior of those employees and those insider accounts, please?
Yes, we will.
The chair apologizes to the gentleman. The chair recognizes again the gentleman from Ohio.
Mr. Chairman, thank you. I would like to recapture the points made by my colleague from New York, Mr. Lent. I think they are most appropriate. Mr. Joseph, what we would like to get to is the whole question of accounts being traded by your employees, the so-called hot issue accounts, in which offerings to the public were withheld by individuals in your corporate employ on the initial public offering date. I refer to the accounts referenced by Mr. Lent, $4 million purchased by Otter Creek, 3.3 purchased by Furtz Strafford, $3 million purchased by Financial Investment Associations, 2 by Concordia Investment, out of a $50 million distribution for Tex Tyrene, which amounts to approximately 25% of the total offering. You advance the theory that there is a distinguishing legal point to be made between the debt and equity issuances vis-a-vis the 34 Act. But the Securities and Exchange Commission has stated, and I quote, "The overall purpose of the rule is to, quote, assure a public distribution of securities for which there is a public demand." A public demand, by the way, I would add parenthetically, that you, as the issuer of this security, are in a unique position to know, having made the roadshow and thus determined the demand for the security that you are taking out. So you are the sole custodian of that information. I continue to read the SEC stated purpose. Continuing to
Mr.
quote.
Eckert, could you identify what you're reading from, at least so we can
I am reading from the Securities and Exchange Act, document dated January 10th, 1983, document number 19414, Lowell, Listrom and Company. To continue my quote, or I will repeat it in its entirety, the overall purpose, the SEC says, is to assure a public distribution of securities for which there is a public demand. to make certain that NASD members do not restrict the supply of the offering by withholding shares, thereby forcing your customers, parenthetically, who want to purchase the securities to acquire them in the market at a higher price, end quote. Legal distinctions aside, Mr. Joseph, how can you assert, given the fiduciary responsibility to your clients and to the marketplace, and in light of the stated overall purpose by the SEC and Blumenthal's reference to the same, and I quote, that an offering should not be sold to restricted accounts when there is public demand for the security, how can you argue that you have been fair to your clients, legalities notwithstanding?
I think I've got to go back a little bit and talk about the difference between the initial market for shares, and I noted that as you were reading those interpretations, it talks specifically about shares and the initial market for bonds. On initial public stock offerings, you very often in a hot new issue market will have issues opening up and trading at premiums over the offering prices that can range from 10 to 50 to 100 to 200%. And it is the opportunity to participate in that very important jump in value in the stock market for newly priced new issues that led to the free rider rules, the NASD rules, and all the firms, including ours, have very careful procedures in place to determine which issues are hot, in quotes, and no employees are allowed to buy shares on a hot new issue.
I appreciate your answer, but my question wasn't a legal interpretation or a fine distinction, which legally may preclude folks from saying that you broke a law.
I'm
trying to talk about the demand made upon you by your clients, who you then seemed to bump out of the way, to elbow in front of.
No, you're using rhetoric which is interesting but not applicable. In the bond market, the issues typically, and even these issues, the initial trades were within 0.5% or 1% or 2% of the offering price. Bonds are essentially fungible. An institution that wants to buy a bond and comes in and tells us, we want to put $10 million to work today in the 13 and a quarter range, there's billions of dollars of issues in that range that they can invest in. And the credit quality of those issues are contiguous, if you will, on this continuum of potential offerings. There's no opportunity to harm someone by holding a bond out of the market or by not allowing them to participate in the issue. Secondly, because these issues trade based on the bottom, sort of the ocean level of treasury bonds, and then the credit perception of the company, scarcity value or lack of scarcity value has very little, if any, effect on where that bond's going to trade. The trading price determines the yield to maturity on the issue, and these are all priced and traded and analyzed based on yields to maturity.
I understand that. The question I want to approach this, and this is my last question because my time is about to expire, is that we have a statement from Lutheran Life's files that they wanted to obtain on the date of the IPO $2 million of the original offering. And they were cut, they were told that they could only obtain $500,000. The records show that perhaps one of the reasons that your customers were told they could not purchase what they wanted was because your folks cut to the head of the line to the tune of 4 and 3 is 7 and 3 and 10, $12 million. Now, why didn't Lutheran Life get a chance to buy what they wanted? Why did your folks get a chance to buy it instead? That's the question I want to know. Why were your clients cut back and your accounts serviced?
I don't know the answer to that question on this issue. I noted that the Lutheran Life did come in and buy some additional bonds in the aftermarket at 100, which is a higher price.
At a premium, because they couldn't buy it at the stated 98 and a quarter.
Not a terribly material premium, I'd point out.
Well, it's not, notwithstanding that, I'm trying to get at the relationship between the seller and the client. And I understand the fine legal distinctions that need to be drawn here, and perhaps they are correct. The question, though, is that your client was cut out of a purchase that folks who had custody of information that your clients didn't bought ahead of them. And I'm trying to figure out how, given the spirit of the law, not maybe the fine legal distinctions, but the spirit of the law as enunciated by the regulator and an expert on it, say your company did not act within the parameters of that spirit. Is that not fair?
I don't think it's fair. I think it ignores the basic fungibility of this massive debt market. I notice that the Lutheran Life memo goes on and say that they're going to use the proceeds to invest in other attractive issues. This is a massive market. There is not a scarcity value. These are not initial public stock offerings.
I understand my time
of the gentleman has expired. The chair recognizes now the gentleman from Florida, Mr. Bilirakis.
Thank you, Mr. Chairman. Mr. Joseph, thank you for voluntarily appearing at this hearing. We're looking today at, among other things, allegations of self-dealing and takeovers. In that connection, I have a fairly lengthy, molded question, if you will. But to lead into that, I guess I'll go into a little bit of a scenario, which is, as I understand it, I trust it's relatively factual. As I understand it, Drexel Burnham has been a financial advisor to Carl Icahn with respect to several takeover attempts, such as ACF Industries, TWA, USX, Phillips Petroleum. In that capacity, Drexel provided financing through issuance of high-yield, as referred to, junk bonds for each of those takeover activities. The public record demonstrates, in connection with the Phillips raid by Mr. Icahn, that Ivan Boesky held a significant interest in Phillips. The public record also reflects that after Mr. Boone Pickens ceased his effort to take over Phillips, the price of Phillips's stock declined. Again, as I understand it, the public record reflects that when Mr. Icahn announced his intention to take over Phillips, the stock of Phillips increased. I understand also that Mr. Icahn and Mr. Boesky knew each other very well, or knew each other well in any case. Mr. Icahn was ultimately paid $25 million for litigation fees by Phillips and received $10 million in profit of sales of his shares. The public record doesn't reflect how much profit Mr. Boesky made on his investment in Phillips. Now, the question that arises is with respect to whether there were any discussions and/or arrangements between Drexel, Mr. Icahn, and Mr. Boesky concerning activities related to the raid on Phillips. And I'll go ahead and put the question to you more specifically. The public record, again, as I understand it, reflects that Drexel provided financing for takeover activities by Mr. Carl Icahn involving Phillips Petroleum Company. So I would ask you, sir, to please advise the committee if at any time prior to or during Mr. Icahn's attempted takeover of Phillips, you or any present or former members of your company had any discussions relating to the Phillips takeover with Mr. Ivan Boesky or any person representing directly or indirectly Mr. Boesky. That's question number one. In addition, did you or any present or former members of your company have any discussions with Mr. Icahn concerning Mr. Boesky and the impact of this takeover attempt on Mr. Boesky's holdings of Phillips' stock? And then I would further ask, if so, please describe the nature of those discussions, when and where they took place, and with whom they took place. If there's anything in writing concerning those discussions, please describe such and provide it to the committee. Now, that is the multifaceted question, sir.
Mr. Chairman, if I might, I think as you can see, I did not come down here to speak very much, but on this particular issue, which does enter into the investigations to which Mr. Joseph referred earlier in his opening statement, we would ask that we be able to respond to the question out of a public forum, if that's appropriate. We're prepared to respond to the question, but we'd not like to do it in this forum.
I'm not clear why it would be necessary for you to do so, nor am I clear as to what would be the basis for this being responded to outside of this public forum.
The basis, Mr. Chairman, with all respect, are the continuing investigations being conducted by the SEC and by...
You're referring to an SEC investigation now ongoing?
And to the Office of the United States Attorney in the Southern District of New York. Both of those investigations are based upon allegations made by Mr. Boesky.
I'm unaware of why that ongoing investigation, either before the SEC or the proceeding involving the U.S. Attorney in New York, would deny you the privilege of responding to the question, or would deny the committee the benefit of the information in connection with this proceeding. Chair will be happy to hear you on that point and then make the necessary decision.
Mr. Chairman, we're not attempting to...
Wait, let me hear from you.
We're not attempting to deny the committee the information. We would simply ask, given the circumstance of the last 16 months, that the information be given either in executive session or in written response to the question.
Mr. Chairman, I'd like to get answers to those questions, and apparently answers exist. I suppose if Mr. Joseph were inclined to answer orally, he has something in mind to respond. And if that is the case, of course you're the chairman, sir, but if that is the case, I am perfectly willing to accept those answers in writing, but they've got to be made a part of the record.
If it is acceptable to the gentleman from Florida, in the interest of fairness, the chair will advise we will receive those answers from Mr. Joseph in writing, understanding that those answers are received as if Mr. Joseph continued to remain on the road.
And I would, excuse me, sir, and I would further ask Mr. Joseph that you may have the answers right at your fingertips. If you don't, and if it's required that you go back and do some inquiring of your own, I would appreciate in your response to us that you share with us that investigation, if you will, whom you talk to regarding your getting to these particular answers. If you would do that, that's part of my request.
Mr. Chairman, I appreciate your courtesy and the courtesy of the congressman from Florida, but I should alert you that no inference should be drawn from my request that this be done privately. We just have been hit over the head so often in the last 16 months in major publications that I very much appreciate your concern for that problem. Thank you very much.
We are in a somewhat adversarial proceeding here. I'm sure you're aware. It is the intention of the chair to provide you and Mr. Joseph with every possible courtesy, even notwithstanding the character of our meeting today. So with that understanding, the information will be received. The chair will review it and will ascertain whether it should be inserted in the record forthwith. I believe that it probably will.
Yes, sir. I would prefer that it be if there is no problem towards that end.
The chair will consult with the gentleman from Florida on this particular point to make sure that he is fully satisfied with the behavior of the chair. And with that, the chair again recognizes the gentleman from Florida, and the chair thanks you, Mr. Flynn.
I would yield the balance of my time, if I may, sir, to Mr. Lent of New York.
I thank the gentleman for yielding. I just wanted to ask, as a follow-on, Mr. Joseph, to the questions from the gentleman from Ohio and me about your regular customers who were cut in ahead of in line by the employee insider accounts. Were your regular customers ever made aware of the existence of these 33 employee insider accounts? Your regular customers ever made aware of their existence?
I certainly don't think they were made aware of 33 accounts or a number of accounts. I think most of our institutional customers, and this is sort of a judgment call, are aware of the fact that the professionals in our high-yield bond department do invest in the high-yield bond market.
Would you want your customers to know that there were these insider employee accounts that very often had a prior call on the issuances of these bonds?
I'd be conflicted, I think, in answering that question from the point of view that I suppose if they knew that our people were buying a particular issue, they'd all want to buy more of it, given the perception that we're quite knowledgeable. So in a funny way, it'd be a marketing tool to tell them that our people were buying it. It would hype the issue, perhaps. But I also think I want to point out that I don't think our people were being given any particular priority. The decision when you have more orders on a bond issue than you have bonds available, which is not uncommon, the decisions as to who gets which bonds involves an awful lot of parameters.
Well, except that we have the parameters set up by the NASD and the SEC, which make it rather clear that the customers come first and the employees take what's left over.
With respect to equity issues?
No. The NASD rule talks in terms of securities.
But then it goes on, I think, to talk in terms of shares, as I understood what Mr. Eckert was saying. But in any case, let me make the point that what you try to do is consider the institution's history of buying these issues with you, whether they are a buyer that tends to keep the issues or tries to trade them out too quickly, and which could put pressure on the market, the size of the order, whether it's an institution that doesn't like some of the restrictive covenants, whether the institution has given you some indication of price, and that indication of yield is higher than the yield at which other institutions are willing to buy the issue, so that on behalf of your corporate issuer, you think you can do it at a lower price, lower yield. A number of factors. The order in which the orders came in would be relevant. An institution that came in earlier would be given precedence over an institution that came in at the wire after the issue was essentially fully sold.
We're not talking about two institutions both making bids and having their bids allocated because there wasn't enough supply. We're talking about an in-house employee group that comes in for a significant share of an underwriting.
I'm not sure they
ahead of regular customers.
No, you say ahead of, Congressman, but I'm not sure they were treated as ahead of. I think they were treated as were other institutional investors. At least I don't know that they were treated in any different way.
Well, just take one of these textyrene corporation, the Lutheran Life, came in and tried to obtain $2 million at the original offering price, which was quite low. And they were only able to obtain $500,000 worth of the bonds. Now, we know that a significant percentage of that offering went to 4, I believe it was, of these employee investor groups, which were buying $5 million and $4 million and $2 million apiece. And here's a regular customer. Lutheran Life is a customer, is it not, of Drexel?
Yes, they are.
Tries to get $2 million and has to settle for $500,000 worth of that issuance. And as I read the Rule 10b of the SEC and these NASD rules, it's not right for an underwriter to bid for or purchase for any account in which it has a beneficial interest any security, not equity, any security, which would include debt, which is the subject of the distribution until that distribution is completed. So the rule requires that the securities come to rest in the hands of the public first, before the underwriter, the employees, the clubs can get in there and begin to purchase. That's my understanding of the rule.
Mr. Chairman, without incurring your wrath, could I say we would also like to brief Rule 10b-6 as well as the NASD free riding rule? That's the Congressman is referring to.
Question and then understand the grounds for that matter. Mr. Lent, would you restate the question, please?
Well, it wasn't so much a question, Mr. Chairman, as I was concluding that as I read Rule 10b of the SEC, particularly Subdivision 6 under the Securities and Exchange Act of 1934, that provision makes it unlawful for an underwriter to bid for or purchase for any account in which it has a beneficial interest any security which is the subject of the distribution until that distribution has been completed. And as I read that rule, which applies to securities as opposed to simply equity, the rule requires that securities come to rest in the hands of the public before the underwriter can begin to purchase for its own account or its employee's own account.
Mr. Chairman,
I think it would be useful, with all respect, gentlemen, that you should respond as best you might today, and we will then receive such additional submissions as you would choose to make.
Would the gentleman from New York yield very briefly?
Well, I don't want to interrupt. I don't want to interrupt the answer if I'm going to get one.
Let's get to answer the question.
Excuse me, I thought you were getting back for the record.
I'd like to answer the question, which is, you know, as I've said, I think our people were treated as were other institutions. Rule 10b-6 is a very complicated rule. I've been in the business for 25 years. I've acted as an underwriter and investment banker for most of my career, and I must tell you, I regularly call outside experts, outside counsel, and ask questions, as do our traders. I think it's a very complicated rule in its interpretations and implementation. And I think it's appropriate, if we can, that we ask Cahill Gooden to submit a memorandum on this. In making those kinds of decisions on an underwriting, we consult with outside counsel regularly.
Well, there is and I hope when you make this submission, you will address the point in Section 13 of Rule 10b, which has a single exception to this rule about taking care of the public and your customers first before you get your own people in there buying. And that is for debt securities that are rated investment grade. So there is an exception. Investment grade debt securities are excluded. And that seems to be the exclusion that you're relying on. But you had acknowledged in your opening statement that your bonds, or the bonds that are the subject of this inquiry, are not investment grade. They are
not, but in terms of the market mechanism, the way they're priced, the way they trade and are priced like bonds, not equities. And as I said,
take a look at that.
It really is complex, and I will ask our counsel to look at that issue specifically.
Thank you. Thank you, Mr. Chairman.
The time of the gentleman has expired. The chair recognizes now the gentleman from Kansas, Mr. Slattery.
Thank you, Mr. Chairman.
Before the chair recognizes the gentleman, the chair notes that the comments and of Mr. Mark L. Samenstad of Lutheran Brotherhood Life will be inserted in the record at this point.
Representatives is in recess until 12:30 p.m. Thank you.
The document referred to will be inserted in the record. Chair recognizes the gentleman from Kansas, Mr. Slattery.
Thank you, Mr. Chairman. Let me just clarify, if I can, for a minute, Mr. Joseph. Is it your interpretation then that Rule 10b-6 of the Securities Exchange Act does not apply to high-yield bonds, or it does apply to high-yield bonds?
I would ask counsel on each case. I'm not qualified to answer that.
Well, how does your company operate? Does it operate as though 10b-6 does apply
not
to...
a simple one-facet rule, as I understand it, and there may be parts of it that are applied.
Well, let me read to you, Mr. Joseph, very quickly, Rule 10b-6. It forbids a broker, dealer, or any other person who is participating in such distribution to purchase for any account in which he has a beneficial interest any security which is the subject of such distribution. My question is a simple one, Mr. Joseph, and that is, as the operator of Drexel Burnham, as in your position, do you believe that your company, when it's marketing high-yield bonds, is subject to Rule 10b-6 or not?
I believe we comply with Rule 10b-6 where it's applicable, and we rely on counsel on specific decisions virtually all the time.
And what you're telling me then is, in the area of high-yield bonds, you don't know whether 10b-6 applies in that area or not?
Do I personally know? I personally do not.
You do not know. Have you ever attempted to inquire?
The issue's never been raised.
The issue has never been raised?
Yeah. Not at my level in the firm. I am not on the underwriting trading.
What does the compliance department say, Mr. Joseph?
I will ask them, and we'll come
You've
back to you
never
with an
asked them
answer.
before?
No, sir, not about Rule 10b-6 with respect to high-yield bonds specifically.
How many dollars worth of these bonds have you sold?
Congressman,
Billions?
Congressman, I'm running a firm that did $4 trillion in transactions last year.
And you're sitting here telling me that in your business, where you have been marketing billions of dollars of these bonds, and you're telling me that you don't know for sure whether the most basic rule involved basically with the Securities Exchange Act of 1934 applies, and you have really never undertaken to find out?
No, I'm not telling you that. I'm telling you it is a very complex rule. It isn't, does the rule apply? It's sentence by sentence, word by word, paragraph by paragraph, and I'm not qualified to answer that question, and don't believe I need to apologize for that.
Let me move on if I can. I want to focus in the time that I have on the BCI transaction. And this involves the initial public offering of BCI Securities. And BCI Holding Company, Inc., of course, is the corporation that was set up to acquire the Beatrice companies in a leveraged buyout in 1986. The Beatrice leveraged buyout was the largest, up to that time at least, involving $2.5 billion in high-yield bonds issued by Drexel. The bonds were sold on April the 10th, 1986, and divided into 4 issues. And one issue was for $950 million at 12.75%, and there were other issues adding up to the total of $2.5 billion. Now, the subcommittee's investigation has identified at least 24 insider accounts which purchased over $235 million of the BCI notes during the April 10th, 1986 distribution. The day they were being distributed, 24 insider accounts purchased $235 million of BCI notes. Now, the insider transactions ranged from a $40 million purchase by Westham Capital, which was owned by Lowell and Michael Milken, to a $170,000 purchase by Lowell Milken IRA. The BCI bonds went up in value almost immediately, and by June the 30th, the insider accounts had resold $61,385,000 of the notes to Drexel for a $2,804,000 profit. The subcommittee staff has also learned that while Drexel insider accounts were purchasing over $115 million of the 12.75% notes, Drexel's public clients were denied BCI notes they wished to purchase. The United High Income Fund is an example. United High Income is a part of the United Group of mutual funds based in Kansas City, Missouri, and the funds have more than 508,000 individual shareholders. The subcommittee staff contacted Mr. Larry Neal, the portfolio manager for the United Fund, who handled its purchase of BCI Securities. And Mr. Neal informed the staff that the United Fund had placed an order with Drexel for $20 million of the 12.75% BCI securities. Mr. Neal then explained that Drexel had allocated United only 80% of the 12.75% notes it had ordered. And Mr. Neal provided the subcommittee a copy of his handwritten note. And Mr. Chairman, I'd like to have that handwritten note entered as part of the record at this point.
Without objection, so ordered.
Now, this handwritten note related to a conversation with a Drexel employee, Bill Toby. The note dated 2 days prior to the April 10th distribution and contemporaneous with the conversation records Mr. Toby stating that United would get only 80% of the allocation. Mr. Neal later filled his order by buying the remaining securities from Drexel on April the 30th at 104. This represents a 4% or 400 basis point premium over the April 10th price. There's further evidence that Northwestern Mutual, which is a Milwaukee, Wisconsin-based life and disability insurance company, and is owned by 3 million policyholders. And according to Mark Dahl, the Northwestern account manager who handled its purchase of BCI notes, Drexel cut back Northwestern's purchases of the notes. Northwestern provided the documents to the subcommittee indicating it placed an order for 15 million of the 12.75% notes, which was cut back by Drexel to 5 million. And Mr. Chairman, I would like that these documents also be made a part of the record.
Without objection, so ordered.
Mr. Chairman, I just like to hear your observations or comments on what I've just indicated, Mr. Joseph, and I don't know whether you're personally familiar with this transaction at all or not, but if my information is accurate, what's your reaction to what I've just provided?
I think my comments are the same as the comments I made with respect to Text Irene. This is a $160 billion market. The Beatrice offering, which aggregated, I think, about $2.5 billion of total financing, was, I think, maybe the largest aggregate financing done up till that time. At the time of the offering, the New York Times stated that because there was so much supply of these bonds, that the price had to be unusually high, or the yield had to be high. There was a lot of concern and question as to whether this issue could be sold in this size. And I think we surveyed all of our institutional accounts, including the employee accounts, which we try not to differentiate.
The evidence that the subcommittee has gathered is very clear, and that is that it certainly appears that there were more buyers for the securities than there were securities available. And in this environment, Drexel employees were buying for their own accounts. Seems to be very clear. Now, let me just further tell you that that Mr. Toby, that I referred to earlier, who informed Mr. Neal, who was representing United Funds, was Mr. Toby from Drexel, who told Mr. Neal that he could only buy 80% of what he would like to buy. And according to a March 11, 1986 letter from Drexel attorneys, Mr. Toby was also a beneficial owner of Otter Creek and Financial Investments, two of the insider accounts. So you had the Drexel representative telling a buyer representing United Funds and 508,000 little shareholders out there that they couldn't buy what they wanted to buy because Mr. Toby, working for Drexel on the day of distribution, Mr. Joseph, wanted to buy for his account. Now that's what the evidence that we have would indicate. And my question to you, Mr. Joseph, is this normal operating procedure with Drexel or not?
I can't answer that question. What I do know is that the employee accounts in aggregate have bought less than 1%, I shouldn't say that, I think it's approximately 1% of the new issues of high-yield bonds that we've underwritten.
Mr. Joseph, let me interrupt you. The point is not whether we're talking about $1 million or $1 billion. The fact of the matter is we're talking, in this case, about many millions of dollars. And my question is, as the boss, so to speak, how is your firm running internally? I mean, is this permitted, this sort of activity, or not?
It is permitted. And
are you telling me, Mr. Joseph, that you don't find any fault with Mr. Tobey's conduct in this situation, where he is telling United Fund, representing 508,000 shareholders, on the day of distribution, the day that you're setting the price, that they can't buy, but we are going to buy. Drexel is going to buy the firm setting the price. And you're telling me that's okay?
Yes, I am. And let me go back to some of the comments I made earlier. First of all, Mr. Tobey is the sales manager. He does not make the determination as to which accounts are, how many of the bonds are sold to which accounts. That is made by the syndicate manager.
Then it sounds like, Mr. Joseph, that the problem may be above Mr. Tobey in the firm.
Laterally, I'd say laterally, not above him. It's about the same level. But the point is that, again, you'd have to go back and research it. We'd have to go back and research it very carefully from the point of view of, did any of the institutions express a price preference to the extent that they think the yield should be higher than the yield we're bringing the issue? We will give them less of the bonds because we're not sure if they're going to keep them. Have they been a historic buyer of our bonds? In what proportions? What pressure points were there in terms of the various securities being offered simultaneously? Were the institutions telling us that they might be willing to buy these bonds, but meanwhile they want us to buy something from them at a price that we may not be interested? These are professionally negotiated transactions in the vast majority of the cases, so that whereas your staff has been able to go through millions of trades at Drexel and pick out 3 that raise some questions, which we'd be glad to research more thoroughly, I don't think it's fair at all to attack the entire system over 2 or 3 specific instances.
Mr. Joseph, I know my time has expired, and I was just trying to get at exactly how your company operates internally and understand precisely your interpretation as the boss, so to speak, of Drexel, how 10b-6 applies to you all. And I would ask, Mr. Chairman, that Mr. Joseph submit for the record any internal compliance memorandums and opinions of counsel on applicability of 10b-6 and the investment grade non-convertibility debt exemption in particular. Would you do that, Mr. Joseph?
Without objections, those will be inserted in the record at the appropriate place. Time of the gentleman has expired. The chair recognizes now the gentleman from Ohio, Mr. Oxley, and will recognize next the gentleman from Minnesota, Mr. Sikorsky.
Thank you, Mr. Chairman. Been testified to that you've got 35 insiders, employees' accounts involving thousands of transactions. Can you cite us some examples of cases where those accounts actually lost money?
I'm positive we can, but I can't off the top of my head because I've not reviewed those accounts, but we'd certainly be pleased to come back to the committee with a list of transactions where they've lost money.
I would appreciate that because obviously the inference is that this was a win-win situation, and I think it would be helpful for the committee to have some indication that these weren't all sure things, and would certainly help our deliberations in that regard. Mr. Joseph, all of us have to deal with pejorative terms in our businesses. The President's got his problems with SDI being described as Star Wars. Those of us from the Midwest are saddled with acid rain, and you apparently are saddled with junk bonds.
Yes, I am.
And I know that you've done some advertising to try to dispel some of the problems with junk bonds. But another another pejorative term is hostile takeover. When you combine hostile takeover and junk bonds, you get a kind of a double negative, a double pejorative. And there's been a great deal of criticism in the press and here in the Congress about hostile takeovers being funded by high-yield bonds. How do you respond to that, and particularly to the criticism that not only do you have these junk bonds financing these hostile takeovers, but that in fact they do nothing to help the economy, but in fact simply transfer wealth around without creating jobs?
I think there's a number of factual responses to those comments, and we do hear that, unfortunately, an awful lot more than the facts would justify. In fact, of all the high-yield financings done by Drexel in the past 8 years, less than 6% of those proceeds have been used to finance or refinance hostile takeovers. And if you turn that looking glass around and look at it from the other direction, of all the financing for hostile takeovers in recent years, less than 10% of it in aggregate has come from the high-yield market. Banks provide approximately 65 to 70%, I believe, of the financing for hostile acquisitions, and the high-yield bond market is not a terribly significant factor in that market. Roughly 25-odd% of the high-yield financings have been used to finance friendly acquisitions of various types, and fully 70% or 69% of all high-yield bond financing has been by companies to finance what is typically their own internal growth, paying for the construction of new plants, inventory accumulation, research and development. You've got to understand that of the roughly 22,000 companies in the country that are large enough to be able to issue bonds in the public market, about 800 have received an investment grade rating, and the rest, if they could do a bond deal, would be a high yield issuer or a junk bond issuer. Our guess is that maybe half of those companies actually would qualify to issue a high yield bond, in that their credit rating, not credit rating, but our credit analysis would lead us to believe that they were worth financing, that we could predict their future cash flows with enough assurance that we'd be willing to underwrite an issue for them. So that by industry, for example, an awful lot of the healthcare companies that have grown in the past decade have used high-yield financing to finance their growth. And of course, these companies that are below the Fortune 500 are the companies that are accounting for all the job growth, or virtually all of the job growth in the country.
Could you, you mentioned the roadshow and the sale of the, and underwriting and the sale of the bonds. Could you give us a profile of the typical investor, the typical purchaser of high-yield bonds?
Yes, I can. They are virtually all institutions. The vast majority of them today have developed their own high-yield bond expertise, in that they have high-yield bond fund managers, traders, and research analysts.
If I could inquire, the institutions, could you break that down further?
Yes, that's just what I was about to do. Probably the primary group are the high-yield mutual funds, which, as I indicated earlier, I think 81 of them have $27 billion in the market. Insurance companies are major buyers of high-yield bonds. Pension funds, typically operating through professional investors, money managers, are very major buyers of high-yield bonds, and there's a segment of money managers now that have developed who are high-yield bond specialists, who run money for the pension funds of many of the largest companies in the country, that have dedicated a portion of their funds to be invested in the high-yield market. Thrifts have been allowed to buy high-yield bonds and have benefited by doing so, although they're a relatively minor investor as a group, probably accounting for about 10%. or maybe perhaps under 10% of all high-yield bond purchases. Foreign institutions are now becoming increasingly interested in buying high-yield bonds and are probably buying, I'm guessing frankly, but something in the order of 5% of the issues at this stage, but an increasing percentage. Individual investors account for a very small proportion of the high-yield bond market. On the typical issue, less than 1% of the issue would go to individuals, and those usually would be extremely wealthy individuals who are rich enough to have a diversified personal portfolio.
Do some of the pension funds, are some of the pension funds prohibited by state law or other types of restrictions from purchasing high-yield bonds?
I'm not sure the answer to that with respect to pension funds. I know there are some limits on insurance companies imposed by some states, despite, frankly, overwhelming evidence that high-yield bonds have been an exceptionally successful fixed income investment, I think perhaps the best fixed income investment vehicle over the past decade for institutional investors. I'm not sure of the rules with respect to pension funds.
I assume that you are bullish on the future of the high-yield bond sales. If so, why? And where would you foresee us in the high-yield market in the next, say, 10 years?
Well, I am bullish on the market. I think if you just go back to the statistics I was using, probably less than 10% of the companies who could raise money by issuing high-yield, fixed-rate, long-term debt have done so to date. It is very clear that U.S. companies, on average, are under-leveraged as compared to German and Japanese companies. And, of course, the lower your leverage, the higher your weighted average cost of capital, because the more equity you're using, and because of the risk involved, equity is always going to be the highest cost capital. So that when you compare U.S. companies to German companies or Japanese companies, their reinvestment required rate for making reinvestments is higher because we have a higher cost of capital, and that is one of the reasons we've been unable to compete internationally. So I think from an individual corporate point of view and from a public policy point of view, increased use of high-yield bonds would make sense. From the investor point of view, they now have had a successful experience investing in high-yield bonds literally from the beginning of the 1900s, and almost without exception in the past decade since the newly issued high-yield bond market developed. And as a result, the cash flow into that market by sophisticated professional investors is continuing to grow. So we think the demand will grow and the supply will grow, so we expect it to be a growing market over the next decade.
Would gentlemen yield on just a housekeeping matter?
Yes.
You asked how many employee partnership accounts there are and the volume. I understand there's a Mr. Kasparian in the audience who could tell you, Mr. Joseph, exactly how many of these accounts there are and what the volume is. Could we get that information for the record? Because it seems that all the members are asking that same question.
I'm not sure if he has that information at his fingertips. We'd be glad to submit it, but if he has it available,
First, I have to find him.
Is Mr. Kasparian here?
You may have anticipated the question.
Possibly. Mr. Chairman, I'll save it then. But
I think, Mr. Chairman, what we'll do is we will obtain that information as soon as feasible and submit it to the committee.
I think it would be very useful that we had the information, gentlemen, if you could submit us the names of all of these employee accounts or insider accounts and the persons who are officers, members, and employees of Drexel who are officers of these employee accounts or who have any beneficial interest in those employee accounts.
Mr. Chairman,
submit that for the record.
Yes, let me clarify that a little bit, because I think the way you just said that, we would have to submit all the accounts of all of our employees. Are you really just talking about accounts where more than one employee is a beneficiary?
No, we'd like to know who all's doing this. It appears we have a little problem here, or maybe we don't in the committee, but maybe you do. And the problem appears to be that these accounts are trading rather freely in issues that are moving in and out either of the activities of Drexel as a primary market maker or as a secondary market maker. And there have been significant questions raised this morning with regard to whether, at least in the limited number of cases that this committee has been able to study, whether in fact these accounts are trading in securities handled by Drexel under circumstances most advantageous to them and possibly more advantageous to them than other investors and traders in possible violation of either 10b-5 or 10b-6 or both. So I think you better plan that on assuming that this committee is going to need the names of all of these so that we can have a look at them. We are particularly interested in the employee trader accounts which fall in the character of clubs, but I think given the circumstances we just better look at them all, Mr. Joseph, if you please. So if you submit them all to us.
I'll have my staff work out with yours exactly what's required, and we'll provide the information you
If you please. Without objection, those will appear at the appropriate place in the record. Chair notes that the time of the gentleman has expired. Chair recognizes the gentleman from Minnesota, Mr. Sikorsky.
Thank you. Thank you, Mr. Chairman. Mr. Joseph, let me recap on the Lutheran Brotherhood Life issue, important issue for Minnesota. Drexel Burnham acted essentially as a salesperson, the underwriter for the Textyrene Company in 1986 when it was selling bonds to the public for the first time. Subcommittee has learned that in the course of selling those bonds, Drexel Burnham asked several Minnesota financial institutions to consider buying Textyrene bonds. One of those investors was the Lutheran Brotherhood Life Insurance Company, and Lutheran Brotherhood is a long-standing client of Drexel Burnham. They've bought a lot of securities your company sells. It's our understanding that the Lutheran Life people looked at the Textyrene offering, as did a lot of other investors, decided they wanted to buy, but when Lutheran Life ordered the securities, Drexel told them they were in heavy demand and that Lutheran Life could get only 25% of what they wanted. A memo which has been introduced into the record from Mr. Mark Simonstead states that this was a new issue in which we had tried to obtain $2 million at the original offering. Due to strong demand for the deal, we were only able to obtain $500,000, or 1/4 of their request. At the same time, however, your insider accounts, or what you call employee investor accounts, bought Textyrene notes at the February 11th, 1986 initial public offering. So far, so good. These accounts were then resold. These insider or employee investor accounts were then resold at a later time to Drexel for $106.50 for a gain of about 8. Correct so far?
I think so. I wasn't paying attention to the numbers, but
well, the numbers are 8.25, 98.25 on the original offering, up to 106.5, 8.25 differential on your insiders' prices. Maybe if we put up a chart, we could see this a little bit better. The subcommittee staff has prepared a chart based on the documents that you've submitted to the subcommittee. The vertical line indicates the prices at which Drexel paid, by which Drexel paid for the Textyrene notes. The horizontal lines reflects the dates. The red line shows the prices that Drexel paid to its insider accounts, and the blue line reflects the prices that Drexel paid to its other clients. Now, earlier on, you talked about the difference between these things and other kinds of securities as the NSAD rules apply and the securities laws generally apply and the rules adopted pursuant to those securities laws apply. And in those discussions, you repeated a couple times that the nature of these kinds of instruments is that when interest rates drop, these instruments become more valuable and their value increases. Is that correct as a general proposition?
When interest rates fall, these
bonds become more valuable.
More valuable.
Well, let me point out, between the time when you paid your insider accounts 106.5 at the last day of February of 1986 and the time that Lutheran Life sold to you, interest on 12th of March 1986, the interest rates actually fell over half a percentage point. But Lutheran Life didn't get the deal that your insider accounts got before. And I'd like to hear an explanation.
Well, I think that chart is fairly misleading. It does take into consideration the size of the transactions. It includes some
Let's hold up there. What's the difference between the size of the transaction on the 28th for the insiders and the size of the transaction on the March 12th?
March 12th?
Yeah.
Which transaction took place on March 12th?
Lutheran Life sold. Are you going to tell me they sold just a little bit so they didn't
No, I'm sorry, I've got, I think, an error in the numbers I was looking at, which showed that transaction on a different day. So I was just trying to understand it.
Well, how does the size relate to this?
Oh, a small bond trade. This is not to explain the Lutheran Life transaction.
I think we got to explain to Minnesota Lutherans.
Okay,
don't mess with Minnesota Lutherans, and we're going to help explain it now. Tell me how they didn't get the price that the insiders got.
Well, I don't have a trace of the bond market, but the bond market was in a period of extreme volatility. And the Drexel sales were made on I think the 27th, 28th of February. The Lutheran insurance company's sales were made on March 12th. And I do not know how interest rates moved during that period.
Interest rates went up over half a percent, or went down over half a percentage. And if your explanation of this bond market is accurate to explain these things that occurred, Lutherans should actually be getting more than the insiders got.
Okay, I just don't have those numbers in front of me.
And if the bond market's so volatile, why have the insiders consistently got paid more than the public, your clients?
Yeah, I think you're looking at 2 or 3 trades over a month. The Lutheran Brotherhood sale was...
Looking at all the transactions in textstyrene.
No, I don't think so.
Yes, we are. And if you can point out some that weren't there, it'd be interesting since the trades came from your information.
How about this? Excuse me a minute, because I've got some different statistics, different trades, and different numbers.
You can submit that. Let me just focus again on the question of all this. How does this stuff come about?
You'll have to rephrase the question. I'm not sure I understand.
How do your public clients, now Lutherans only got 1/4 of what they asked for, because a fourth of the sales went to people who elbowed in. And in hockey in Minnesota, we play it tough, check, tough, and the rest of it. But not in these kinds of things. This should not be a case where whoever checks the hardest gets first in line. Your people got 1/4 of this offering when the Lutheran Life in Minnesota wanted 4 times what they got. After being sold, that textstyrene was a good offering by your people. They came out, did the road show, our people bought in, other Minnesota company bought in, and then they got 1/4 of what they asked for, and when it all comes to the end, they got paid less than your insider accounts. And the question is that fair?
I just simply cannot tell you all of the considerations that went into one trade in one bond 4 years ago, a year ago. The Lutherans bought these bonds at 100. They sold them within a month at 104 125. The company's credit situation
Wait a minute. If they had been able to get the $2 million, which they asked for, and those bonds not go to your insider accounts, they would have made much more. Second point, if they, in the secondary market, would have been able to get what your insiders got when they sold back their bonds, they would have gotten even much more. And that's the point. Why the difference between these Lutherans from Minnesota and your insider accounts?
Because I don't know the perception of that credit in the market during those several week periods. The common stock of the company was in the market, trading quite volatilely. And for example, the trading price in the common stock will reflect people's perception of a company's credit.
Let's back up then. On February 28th, your insider accounts got 106.5.
That's right.
The day before, on February 27th, Guarantee Federal S&L, not an insider, got 103. What happened in that time frame that was so volatile that...
It's the same question. I don't know if the stock was going up or down. The stock was very volatile. The bond market was extremely volatile, and I don't know where it went.
Well, you're saying stock now. I thought we were talking about bonds.
No, what I'm saying is that the price of a high-yield bond will sometimes move based on a change in the perception of the credit. Text Irene became a troubled credit down the road. The stock fell from, on an index basis, something like...
In June of that year.
It was down from something like 127 to 112 on a rough graph I'm looking at between mid-February and early March.
I appreciate the Chair's indulgence, and I will look forward to a submission.
Okay, we would like to make a submission.
Explaining this, and I'll look forward with great curiosity. I thank you for...
we will make such a submission.
Thank you.
Time of the gentleman has expired. Chair recognizes next the gentleman from Colorado, Mr. Schaefer, and then the gentleman from Ohio, Mr. Lucan.
Thank you very much, Mr. Chairman.
The gentleman from Ohio, or rather from Colorado, is recognized.
Thank you, Mr. Chairman. It's clear from the line of questioning here today that we're dealing with an extremely complicated issue, Mr. Joseph, and do appreciate you taking the time to come in and try and enlighten us a bit. Could you give me a little bit of explanation on the secondary market trading and how this all begins? You do quite a bit in this, right?
Yes, we do.
Can you give me some idea on how the trading in these bonds begin?
Yes, I can. First of all, I should point out that as of today, virtually all of the large securities firms, I think probably, I'm guessing, but maybe 17 out of the 20 largest securities firms have high-yield bond trading departments. When a bond's issued, depending on the aftermarket interest in the issue, some of the institutions may come back and decide they'd like to sell the bond. They will call the underwriter, typically, and get a quote from him. If there are other participating underwriters, they will probably get quotes from them. And they will usually check around the other active participants in the high-yield bond market to see if any of them are willing to buy the issue. As a practical matter, these prices are virtually all negotiated between professionals, between the traders on the trading desk of the institution and the traders in the high-yield bond departments of the various securities firms. We think today that Drexel accounts for about, and there's no statistical way to substantiate this, but our estimate is that we account for about 1/3 or less than 1/3 of the aftermarket trading in high-yield bonds. When we confirm the pricing of our high-yield bond inventory, we go to other firms to get quotes and find that in the vast majority of issues, there are competitive quotes in the marketplace.
Well, do other brokerage houses become market makers in securities that Drexel, for example, would underwrite?
Yes, they do.
In some cases, Drexel is the sole market maker. Is there anything that you see wrong with that particular
There's nothing wrong with it. It's not a desirable situation. You'd rather see more than one market maker. We like to be able to trade with counterparties. It always gives me comfort as the chief executive of the firm to know there are other firms making a market so that we can check their pricing ideas, which is effectively checking their ideas as to the quality of that credit on the continuum. But there is nothing wrong with it. Very often, in fact, the one market maker is providing a very substantial service to the holders because he is providing liquidity.
All right, let's shift gears a second on the total Hanover Petroleum transaction. Could you explain the exchange agreement that's at issue here in this Hanover Petroleum issue? And what did Drexel agree to do under this agreement?
That's a pretty broad question. I'll try.
Within my 3-minute time limit that I have left or whatever.
On Hanover Petroleum, this transaction is, I think, 5 years, goes back 5 years, so it's difficult to recall. We agreed to exchange, to tender bonds to the company and go out in the market and try to buy them for them in exchange for cash, which cash the company was going to raise through a underwritten stock offering, which we co-managed. The arrangement was designed so that for technical reasons, given the indenture of the company, they could not redeem the bonds, so that we were positioned so that we could buy the bonds, and the understanding was that they would all be tendered to the company at, I think, a price of 104.5. But we structured the agreement so it was our option whether to tender them at the 104.5 price or to wait till the company redeemed them, which would be at 104.5 plus interest down the road. And we were protected against having to pay a higher price than the market price by a price adjustment clause in the agreement, which effectively said the company would pay us our cost. And it was contemplated that that would be in case we had to pay a higher price for the bonds.
Well, when the Total Petroleum decided to go forward on this deal, what kind of a public notice and filings were made?
There was a public notice put out, I think, on June 8th, quite a bit before the transactions took place. The public offering of the stock, I think, took place on June 27th or June 28th.
Well, is this the way notices are usually put out in this kind of a transaction?
No, this was a unique transaction. It was designed to find a way for the company to redeem some expensive debt by issuing equity if the equity could be sold. If you remember, 1983 was a difficult environment for energy companies, and there was great concern as to whether the stock issue could be done. And the idea was that we thought we could do it. If we could do it, the company would want to redeem the bonds. So we had some chicken and egg problems to work through.
Well, this went out in the Dow Jones Newswire.
Yes, but it was all public information well before the commencement of the activities.
Okay, as a final wind-up here, Mr. Chairman, Drexel purchased $5 million of these bonds in question on June 21 at a price of $1,005. And this raises a couple questions. First of all, was this trade solicited by Drexel or by the seller itself?
I'm sorry, Mr. Schaefer, I missed the question.
All right. Drexel purchased $5 million of these bonds in questions on the 21st of June at a price of $1,005. Was this trade solicited by Drexel or by the seller?
I don't know if it was a solicited or unsolicited order. We can find that out and would be glad to find that out and come back to the committee with that information.
Oh, I would appreciate that, Mr. Chairman, if we could. And was the seller notified of the potential redemption at $1,045?
The seller is a professional institution. It had gone out on the wire services on June 8th that the company intended to make the redemption, and we had filed the red herring for the offering of the stock or the units, and that had been was public information. We'd filed that also on June 8th, and that also was public information. So you certainly would have expected them to be informed.
Well, how was that price of $1,005 determined? Was this a quote by Drexel, an offer by the seller? Was this a negotiated price?
I would assume it was a negotiated price between our trader and Reliance Standard Life's trader.
Well, could you see it, Mr. Chairman, if we might get the answers to these questions? You assume that. I'd appreciate knowing whether and how that all transpired.
I will have to have our people go back and chat with our traders and see if they recollect. Remember, this is 5 years ago, and
I understand
they may not remember, but we'll try to ascertain that.
Thank you. Mr. Chairman, thank you.
Time of the gentleman has expired. The gentleman from Oregon.
Thank you, Mr. Chairman. Mr. Joseph, my colleagues have talked about the Textyrene case and the BCI cases in some depth now, and I think the question that I would really like to know is, how can you conclude that the issuers got the best deal possible in Textyrene and BCI when immediately after the issue, your insider accounts were trading the bonds at a significant premium in the secondary market?
I think there's several ways. First of all, again, I'd like to go back and point out that what you describe as immediately after the offering, they were trading them in the secondary market at a significant premium, that the whole bond market had risen by proportionate amounts during that period. And in the very immediate aftermarket, the bonds were trading at a very modest premium. There were some trades at 100, which is modest. But let me, I can answer, I'm picking on the words as opposed, let me answer the question if I may. The fact is that the price of all of the initial public bond offerings are negotiated between the corporate finance professionals in our firm who really view as their client the corporate issuer, but represent the firm and the issuer. The issuer typically is a fairly sizable company. Our average issuer has total assets of about $1 billion. And as we go through the period of the offering, typically we have told them what we anticipate the price to be before we file the registration statement. We then very often will develop an index of most comparable companies. Again, on that continuum I keep talking about, which is the critical variable in understanding exactly where an issue is going to be priced, we will talk to the company about which issues are the most comparable. And keep them informed of those issues. Then as we go out on the road show, they will have direct conversations with some of the institutions. Clearly the institutions have their own agenda, which is to try to convince the company the yield should be a little higher, but there'll be some direct conversations between the issuer and the institutional buyers. We will keep the company informed and very often open up our book to them and show them which orders we've gotten from which institutions, which of those institutions, if any, have given us price limits or said they won't participate if it's not the right price, so that they and we both have a background of negotiations coming into the pricing conversations. Once we sit down and discuss it, the range is typically very narrow. As I indicated earlier, usually less than 1/8%. And frankly, I must tell you that very often the company is having back corridor conversations with other underwriters who are not at all reluctant to call a company when they're doing an underwriting with a firm and tell them what they think the price can be, why they think they could do it on better price. So we suspect they're getting input from the market away from the underwriter as to the anticipated terms. And then, of course, the company does get to see how the bonds trade in the immediate aftermarket. And the proof of the pudding, I think, is that virtually all of our issuers have come back to us to do additional issues, and the issues have typically not jumped out of line with any moves in the market.
Well, they certainly, in the cases that my colleagues are talking about, redounded to the benefit of your insiders. Right. And I just find it very hard to really understand how under your system the issuers would have the same access to information that the insiders have. And I think that's right at the heart of what we're concerned about.
Well, first of all, you know, the staff investigators have chosen 2 issues out of 350-odd bond issues.
You have made that point repeatedly, and it seems to me that when you're talking about unfairness, which is really what this subcommittee is concerned about, unfairness is unfairness, and those were real people, citizens of Minnesota, citizens of the Midwest, citizens where the evidence seems to indicate that they were not afforded the same investment opportunities the insiders were. And just because you say there were only a few trades doesn't mean that this is unimportant.
Oh, but the statistical evidence counts. We've got 350 corporate finance issuers who've issued bonds through us. We have 20 powerful competitors trying to take those accounts away from us.
I might note that your competitor has indicated that he won't permit the kind of inside accounts on the basis of this morning's newspaper.
That was the director of research in that competitor's firm. Let me point out that these individuals you're talking about, and we do care about the public perception and the public confidence in the market, they have been represented in their negotiations to purchase and sell bonds with Drexel by professional high-yield bond investors. And you know, the buyers and the sellers in this market are virtually all professionals.
Mr. Chairman, I thank you for that short question.
Chair thanks the gentleman. Mr. Joseph, we've kept you here a long time. I think it would be appropriate that the committee should break for lunch and we should return again at the end of about an hour. Would that meet your approval?
That would be fine.
Very good.
Mr. Chairman.
Then the chair announces that it is now 5 minutes to 1. The committee will recess and we will return here at 2 o'clock.
Mr. Chairman, do you want to put those staff-generated...
Gentleman has a unanimous consent request?
Unanimous consent. I ask unanimous consent that the chart and similar materials like that generated by the staff supplied to the witness be put in the record at the appropriate place.
Without objection, so ordered.
Thank you.
Committee stands adjourned until 2 o'clock.
C-SPAN's coverage of this hearing on securities laws will continue in just a moment.
There's no better way to plan your C-SPAN viewing than with the C-SPAN Update. The Update is C-SPAN's weekly newspaper, which highlights events that air on the network. Call 1-800-321-5100 and we'll send you 50 issues of the Update for just $24. When you order, we'll also send you a free gift, our Road to the White House poster, a pen and ink drawing that depicts C-SPAN's grassroots approach to the campaign. Call 1-800-321-5100.
You're watching C-SPAN, and right now we'd like to pause briefly to look at programs ahead. Coming up at 8 a.m. Eastern Time, 5 Pacific, it's a recorded call-in program on the role of paid media in political campaigns. You'll see and hear radio and television ads presently being used by the presidential candidates. We'll follow that with highlights from a Washington seminar for constituents held by the office of Colorado Senator Timothy Worth. Finally, at 10:15 a.m. Eastern Time, 7:15 Pacific, Secretary of State George Shultz is the featured speaker at a dinner hosted by the Massachusetts Institute of Technology. Right now, we return to our coverage of Thursday's hearing on securities laws before the House Energy and Commerce Subcommittee on Oversight and Investigations.
Subcommittee will come to order. This is a continuation of the hearings commenced earlier this morning with regard to high-interest bonds and matters related to their sale. Chair recognizes the gentleman from Oregon.
Thank you very much, Mr. Chairman. I'd like to have the staff put up a chart, the other chart at this time, so we could use that. The only other one we have over there.
Get into the question before he gets a chance.
Now, Mr. Joseph, you have said that interest rates determine prices, and that interest rates go down and prices go up, and that in effect has been your explanation as to why some of these insiders made more on their deals. Now, the subcommittee has hired a company, pricing services, whose job it is to price the value of securities. And they've compared textyrene to similar securities to factor in interest rates and maturity and risk and things of that nature. So what we've got on this chart, the lower line is the one done by pricing services. And the upper line is the prices that the insiders got. So you can see for textyrene, even factoring in for these objective kinds of criteria, that there's a big difference. The insiders make more on their transactions. Could you offer an explanation that would make that chart seem other than it appears to me?
I would have trouble doing that, Congressman. If I could have an opportunity to analyze the basis on which the pricing company priced these issues, which issues they considered comparable, and the basis for their reaching their assumptions, I might be able to deal with it. But let me, before you do that, or let me go on a little bit beyond that. These prices are negotiated prices negotiated by institutions. The Lutheran Brotherhood, which we've talked about this morning, is a multi-billion-dollar institution, totally capable of representing itself in pricing negotiations. The trade we talked about this morning, which I think occurred at 103 or 104, was the only trade, according to the sheets you gave us, that occurred during a period of several days in the Securities. Negotiating the price of a specific bond at a specific point in time with a specific seller is going to depend on issues like what your inventory position is. Are you looking to increase your inventory or reduce it? How does the calendar look to you?
But Mr. Joseph, isn't it true that the insiders are negotiating with themselves? The very same people who are doing the buying are doing the selling.
Well, I think what you've got to understand is that we watch the pricing of our high-yield inventory at the firm level above the members of that department very closely. It is a multi-billion-dollar inventory. We check the prices ourselves in New York with other firms. We have an internal audit department that checks them. Our outside auditors check the prices. And we have never found a reason to feel that the prices were inconsistent.
You've said then that you price this yourselves within the firm. What I'd like to do then is show you a memorandum, and I think the staff can make this available to you. It is a memo, an account statement specifically from Drexel Burnham Lambert to Otter Creek, dealing with the price as of 2/28. And it's page 2 of your materials, I think, and you have to turn the page to get the graph. I'm sorry, turn the graph to get the report. It's page 2 of your material. What does it say the price of textyrene is there as of 2/28? Well, it says...
I'm having trouble reading it. Just give us one moment, please.
It says the price as of 2/28 for textyrene is 101.5. Mr. Chairman, I would like to ask unanimous consent to have that put into the record at this point.
Without objection, so ordered.
And look down the list to textyrene and look across to the price. The point is, Mr. Joseph, pricing service says it's worth 101.5. Drexel is telling Otter Creek and the world it's worth 101.5. But on that very same day, 2/28, the insiders were getting 106.5. What I'd like to know is how between 9 o'clock in the morning and 4 in the afternoon, things went up 5 points.
I'm not sure I can explain it because I wasn't there, but let me say that the pricing services are typically not all that accurate. I don't know where the 101.50...
This is the price that you all set.
I understand
Just as you said, you negotiate. It's the price that is in your account statement, a matter of record at the firm, from the firm to Otter Creek. This is not a question of pricing service. This is a question of within one day, what you said it was worth was 101.5, and the insiders on that same day got 106.5.
Right, let me just point out that I believe on the following workday, I think that was a Friday, and I think March 3rd was the following Monday, an institution paid 108.21 for these bonds. So the price clearly was moving up.
What institution was that?
Executive Life, I believe.
Does Executive Life have any relationship with Michael Milken?
Executive Life is a large institutional client, a large buyer and seller of high-yield bonds.
Is it the largest in the field?
I don't know if it is or not.
Well, gentlemen, you know,
I'd be happy on the chair.
Executive Life owns, I believe, 1/2 of an insider account.
No, I think what the chairman's talking about is that Executive Life has a...
Don't they own half of First Stratford?
I think it's a subsidiary, which they own half of, and members of our high-yield bond department own roughly half of. It's a reinsurance company.
Well, gentlemen, you just to help me understand this, why on February 11th are the prices on the chart, according to Drexel's figures, the same? Why on February 21st are they 98 and let's say 3/8 or something like that for an insider account, or I'm sorry, for a pricing company price, and for an insider account, why are they 106 on the 21st? And why have they gone to 106 and a fraction for insiders on the 28th, but for pricing company prices, they are 102 or 101.
101.5.
Now, why would that be? What is the reason for that?
Well, I cannot explain the pricing company's prices. I know nothing about their methodology
But Mr. Joseph, those are what you have set the price on. That's this memo. This is an account statement from Drexel. It's not pricing services, it's yours.
Let me say that the actual price of the bonds during the period is the price at which the bonds traded. And if you come down a sequential list of the trades in the bonds, you find that they all opened, and the reason they're all at the same price at the opening is the bonds were offered 98.25, and that's where they were on the 11th. The trades after the 11th, according to the sheet I have, is that 4 million traded at 101, 500,000 traded at 100, 100,000 traded at 100.5, another 100.5, then 3 million plus traded at 104, 1 million traded at 103, 2 million, 4 million, and 3 million. The employee-related accounts did trades at 106.5. Executive Life bought bonds at 108.2, and the Lutheran Brotherhood sold bonds at 104 and a quarter.
Remember, we've already agreed that Executive Life is half owner of one of these insider accounts.
It's half owner of a reinsurance company that the members of our department own an interest in. Executive Life is an independent entity which is very knowledgeable in the high-yield bond business. And I don't believe our people have any significant ownership.
They don't have any interest, then, in one of these insider accounts?
No, sir. It's a different, I think it's a different.
My information is that they are
First Stratford is not an employee account. It is run by Executive Life.
Mr. Chairman?
Pardon? Now, do they have any employees?
Does
this life insurance company, do they have any employees?
Stratford.
Of their own?
Well, Executive Life runs, First Stratford is a reinsurance company, which is a subsidiary of Executive Life. I'm not sure
They
how
don't have any employees of their own, do they?
I don't know how they share their employees, sir.
And as a matter of fact, they do business out of Drexel's offices, and the people who do their clerical functions are employees of Drexel. Is that not so?
I'm not aware of that.
Mr. Chairman?
Very well. Thank you.
Mr. Chairman, if I could just...
Gentleman from Oregon.
Well, Mr. Joseph, on this account statement, you tell Otter Creek it's worth 101.5, and yet you pay Otter Creek 106.5. What is going on here?
I don't understand that pricing on the day of that trade.
Are you concerned at all about it? Isn't that essentially the kind of opportunity for insiders that your customers would be concerned that they weren't getting?
I would be, but again, I'd like to point out that the meaningful market is the market at which trades are taking place. The trades on both sides of the 106.5 trade were the original, the one before it was done at 103, the one after it was done at 108.
My time has expired, but it seems to me that your own account statements show that there is a widespread problem with these kinds of practices, and I can't figure out why you're defending it here rather than repudiating it.
What I've said is I cannot explain and don't understand the difference between the price of that trade and the account statement. There may in fact have been an error, but the important fact
Where would the error have been in your account statement?
It's conceivable there can be an error in an account statement, yes, sir.
We have found 4 account statements with the same price on the same day.
If the security was mispriced in the account statement, it would have been mispriced in all of them because it's run off by computers.
My time has expired. Thank you, Mr.
Time
Chairman.
the gentleman has expired. Chair recognizes the gentleman from Florida, Mr. Bilirakis.
Thank you, Mr. Chairman. Mr. Joseph, do other broker-dealers allow their employees to buy securities that the firm is underwriting?
I believe they do.
Do you know specifically of which firms do?
I can't tell you because I haven't checked recently, but I have worked at 2 other firms that would allow employees to buy securities on underwritings, providing that they were not hot issues under the NASD rules. And my guess is that most firms will allow employees to buy securities on underwritings as long as the security is not a hot issue.
Provided they're not hot issues.
Yes, sir.
And I know that's been talked about before, but I guess that's sort of a subjective definition, isn't it?
Well, but there are some pretty firm understandings of what that means. It applies to equity securities, and we all have developed mechanisms for determining and letting our entire system know whether we consider an issue hot or not, or eligible for employee purchases. If it would be helpful, we'd be glad to survey the 20 largest firms and find out what their procedures are and make the information available to the committee.
Well, I'm not sure that that's something we should be expecting from you. Solomon Brothers, do you know if they permit their employees to invest in new issues?
I don't know. I read the statement in the New York Times this morning, and I don't know whether that's an accurate reflection of their policy or not.
Well, Mr. Joseph, so much, and you've been really great, there's no question about it, although you have had an opportunity to eat lunch at least, and more often than not, that's not the case in hearings that we have. But we can spend hours and days and weeks, and I guess we're going to, on this issue and pick specific instances that many have been discussed here today, many others are going to be today and at future times. And I'm not really sure, other than maybe determining specific violations, whether we're ever going to really solve the problem. And I think you would admit there's a problem there, because if there's a perceived problem, that can be even worse than an actual. I'm sure you realize that. So I'm just wondering, should this practice of a broker-dealer allowing their employees to buy securities that the firm is underwriting, should it be banned? Should it be further restricted?
I'm not sure what the answer to that question really ought to be. I think I'm comfortable that we have complied with the existing rules. I agree with your statement that if there's a perceived problem, then we ought to consider doing something about it. Our firm has no confusion. We know that the public participation in the market is based on the public's perception that the markets are fair, and it's critically important that they have confidence in the markets and in the firms that are acting as securities brokers and dealers, so that if in fact there's a perception that it could be unfair or is unfair in the way it's working, then we'd certainly be interested in trying to work towards solution.
I mean, don't you really inside in your heart feel that there's probably that kind of a perception among the public? It isn't just the members of the Energy and Commerce Committee and John Dingo who might feel that way.
Well, I'm really not sure, because I go back to the fact that this is a professional bond market. I think the professional institutions that deal in this market understand it, and understand the pricing, and understand the various firms' positions, and the buyers do deal with our firm, which we're pleased that they're doing it. We don't want to give them any reason to be discouraged from dealing with our firm. But I'm not entirely sure, sitting here today, taking this pounding, whether in fact our client constituencies would agree with the panel.
Well, I've always thought that, I made my comments earlier about the reason for this system in the first place, and it's a good reason. It's just as American as apple pie. It certainly is consistent with our capitalistic philosophy. But, you know, particularly after the, October 19th, whatever that Black Day was, the Black Monday was, that it's become more of a crapshoot, and maybe even worse, crapshoot as long as it's as long as the dice are not worked on. You've got some odds on your sides. But when the general public gets involved in something like this, and then they have the feeling they're insiders, or there may be insiders, and I'm not, alleging that, then that's where I suppose the Congress has got to open up its eyes and say, hey, there's got to be some protections here. So I'm just wondering if, with lack of policing, self-policing, if you will, by not only the SEC but the firms themselves, if we aren't heading maybe from one extreme to the other. And I guess I'm just about as pro-business as you could be, and I believe in the system, as I said earlier, but right about now, if I had to cast a vote on whether maybe this sort of practice ought to be banned, I think I would seriously consider it.
Well, I think you're talking about two different things. One is, of course, the equity market, which is really what Black Monday, October 19th, was about. And we at Drexel and all the major securities firms are very concerned about the public's perception of the negative perception of the volatility in the equity market is symbolized by that day, and the public has not participated in the equity markets since then to the extent they have before that, which is of course a
But when
matter
the
of
public
concern
picks
to
up
us.
the newspaper and reads about, you know, the litigation and hearings such as this and whatnot, I mean, you know, you're talking about a perception which is certainly tied in to, you know, the Black Monday, and there isn't any question about that.
I want to just differentiate that from the high-yield bond market because the press talked about the collapse of the stock in the high-yield bond market. The fact is the high-yield bond market fell perhaps 3% in late October when the stock market was going down over 20, and within a month the high-yield bond market had recovered. And again, I think it's very important to understand that probably at least 99% of the high-yield bonds are purchased by professional investors that are really full-time professionals dealing in the high-yield market. But to the extent there's a perception that the playing field's not level, then we'd be interested in trying to figure out how to improve that perception.
If in fact there was a ban enacted, and now how do you feel that what would that do? What would that do to the overall picture? What would it do to Drexel Burnham? What would it do in terms of, would it hurt you in terms of employees? Would people get out of the business because they can't deal in it themselves? Is Solomon having a tougher time, assuming now that they don't allow their employees to engage in this practice? Are they having a tough time getting good employees, tougher than Drexel, which does allow them to do it?
Well, I think several things. I won't talk about Solomon's ability to recruit people compared to Drexel's, although I'd love to. I think this is probably an inappropriate forum. I think I should point out that the total purchases of our new issues by our employee-related accounts is accounted to approximately 1% of the total purchases of these bonds. They have not been a material factor in the market, and our employees, I believe, have only participated in about 7% of the issues. So that if there were a ban, I don't think it would have any material effect on the marketability of the bonds or our ability to maintain a market in these bonds.
But excuse me, so the Textarine bonds that was talked about previously, I mean, that's 25% of the issue.
Yeah, no, in some specific issues, they have bought more. In Textarine, I think the employee-related accounts actually bought more like 18%, but the point's the same.
Yeah.
So that in some issues, they've been a major factor, obviously. I do not think that such a ban, which I think is necessary, but I also think that such a ban would not adversely affect our ability to retain our employees. It just would lend to somewhat less efficiency in the marketplace and in our ability to encourage them to pool their resources and not be spending time each one running their own investment account.
Thank you, Mr. Joseph. Thank you, Mr. Chairman.
The gentleman from Ohio should be recognized. I think, Mr. Chairman, then I'll be recognized.
Chair recognizes the gentleman from Ohio, Mr. Eckert.
I thank the chairman, and I thank my friend from Kansas. We both seem to be in scheduling conflicts. Mr. Joseph, thank you for returning.
I wasn't sure I realized I had a choice.
Well, we thank you for returning anyway. You did, yeah, we did acknowledge the fact that you told us this morning that you came here voluntarily. So this morning's Washington Post has a point of an article in it which my colleague from Florida touched upon, and I would like to pursue, and that is, of course, a comment from one of your competitors talking about how we prohibit that, referring to having employees being permitted to invest in new issues that the firm is selling to investors. If you're an underwriter of a security, you know that the demand is for the security. We view it as a conflict of interest. We certainly can acknowledge the difficult nature of your business, but during the recess, I asked my staff to contact your competitors to put the same question to Salomon Brothers, to them that was put to Salomon Brothers in this morning's Washington Post. And I guess I'm prepared to say to you that it's virtually unanimous, but for Drexel. The other major investment firms who responded, And Mr. Chairman, we're going to send a letter to all firms surveying them on the particular question raised here. Asserted, and one voluntarily, and these were calls we made to New York, that the NASD rules should apply, and they in fact either apply them or would apply them, or would interpret them such that they should be applied. I think the net effect is that kind of has you as the one person out there. And while it's a legal debate, it sounds a little bit like my time in theology class when we had folks arguing how many angels could dance on the head of a pin. You have a number of lawyers who say that what you did is appropriate, and there's a number of lawyers who say that you didn't. The net result, though, is three things. One, in certainly not a comprehensive, but nonetheless survey of 5 of your major competitors, I cannot find one who says that they would do or act the way your company has acted. That's first. Secondly, they said that they would assert the rules in an issue such as has been discussed here in a way that would not leave confidence of the public in question as to your activities. And third, focusing, Mr. Chairman, if I may, on what you said earlier this morning. And I kind of chewed it over in my office over my soup from the Longworth cafeteria. You said the last 17 months have been difficult. No securities firm has ever had to endure the kind of intensive investigations now underway or the torrent of adverse publicity with which we have experienced. That's a direct quote from your written testimony. We've heard a lot about what price was sold when and who did it and who profited from it. You've said that you do not believe the way your company comported itself to be illegal, and you have substantial legal opinion to support your answer. You have said that there are a number of factors that could have contributed to this result. But the end of the result is, a bottom line if you will, is that your company's actions appear to be out of the mainstream of actions of your competitors and have, in your own words, brought about a torrent of adverse publicity to you and to your firm. The net result being is that the public perception is that what you have done does not pass the smell test. If you are so concerned about this torrent of adverse publicity which your firm has experienced, yet you sit here and defend a practice asserting appropriate legal theory for what you have done in clearly what is viewed to be a division of legal opinion, why do you continue to defend that practice, so much so that it will only contribute to further adverse publicity for you?
I think we're mixing up some apples and oranges and fruit salad a little bit. The adverse publicity has come out of the Boski-related events, which are certainly A, unfortunate, and B, involved illegal activity on his part, certainly, and did harm to the markets. What we're talking about today is a practice with regard to the distribution of securities, where frankly I'm surprised at the conclusions of 5 other major firms, and wonder but accept it, although I wonder if they were thinking about the same kinds of securities and the same sorts of situations as the ones we've been talking about. But I agree with you that, in fact, smell test is very important in our business. I think the real test is our relationships with our sophisticated clientele on both sides of these transactions, the issuers and the institutional buyers, and I think their loyalty is a good indication that they think Drexel has, in fact, passed the ethics test in terms of how we deal with our clientele.
Will you use this opportunity today to tell your clients, this committee, and investors who may not be your clients today but would have an interest in so doing, that in order to avoid future adverse publicity, you will order a cessation to these kinds of investment practices?
What I think I should do, because I really want to think through the fairness of that from both sides, is have our people analyze it and think it through carefully. The fact is that our people are investing in the market, in the securities that we're offering for clients, and I'm not entirely sure that that's not beneficial.
The question is, Mr. Josephson, beneficial for who?
I think perhaps beneficial for the issuing company by increasing the size of the market and the money invested in that market. I think the perception that our people could have been buying securities that clients would have wanted to buy and couldn't have bought is a harmful perception. I don't think it's an accurate reflection of the facts in the market, given the depth and breadth of the market. But I think from the firm's point of view, we've got a stake in making sure we can either persuasively convince people that the perception that it ought to be that it's okay and that it is good for Drexel people to be buying high-yield bonds, showing that we're committed to that market and we like the market and we like the issues we're doing. And if we cannot clean up that perceptual question, then I'd certainly be willing to consider some sort of restriction to prevent that adverse reaction.
We often in the cloakroom kid each other about the kinds of votes that we cast. And it's kind of a rule of thumb, Mr. Chairman, as I see you waving the magic wand of timeliness, that if it takes longer than a 30-second TV commercial to explain your vote, you may very well have cast the wrong vote. I am submitting to you that perception for you is reality, and that the question of profitability to the clients who would much rather see the money from these issuances go to them to create more jobs, to the public upon whom the confidence of your organization as an innovator in a creative financing scheme that has enabled thousands of jobs to be created and preserved, a point that I think should be conceded. And even more fundamentally, in the events of the most recent investigations, seem to me to be that you would want to take whatever opportunity you can, sua sponte, to correct it yourself. I think this hearing affords you that opportunity, and I certainly hope you'll reconsider that consider that in your analysis, and I thank the Chairman for his tolerance and the time.
Time of the gentleman has expired. Chair recognizes the gentleman from New York, Mr. Lynn.
Thank you, Mr. Chairman. I'd like to just get to an issue that does concern me and a number of other members of the subcommittee regarding Drexel's role as financial advisor to the home shopping network, which has filed a lawsuit against Drexel for fraudulent manipulation of home shopping network's stock. Mr. Joseph, are you, generally speaking, familiar with the $100 million bond issue of early 1987, where Drexel was the underwriter?
Only in a very general way.
Well, as I understand it, there was an initial conversion price in these bonds of $25.80. And then shortly after the transaction was closed, which was in April of 1987, Drexel came back to Home Shopping Network and advised them to reset the conversion price. Are you familiar with that?
Yes, I am.
Can you tell us why that reset was demanded by Drexel?
I can in general terms.
Okay, go ahead.
The company's stock was dropping quite sharply at that time, reflecting deteriorating expectations in the marketplace, I think, about the company's prospects. And I don't have the numbers in front of me, but we did the issue at price X, and the stock was trading at quite a bit below X very quickly. And the investors that had bought the issue were, I'd say, hysterical, to put it mildly. They were very, very upset and really telling our people in no uncertain terms how upset they were with the company, with the investment, with Drexel. And we went back and talked to the company about it and explained that, this was going to leave a bad taste in the mouths of these institutional investors. And after extensive discussions, I gather, the company agreed to go to a reset price, which is a not common but not terribly uncommon way of giving investors in a convertible security some confidence that the conversion feature will have value. And the management's view at the time, I've been told, was that the stock would go back up and therefore this wasn't going to hurt them. From the investor's point of view, it gave them a lot of additional protection. This is all second and third hand. I've not investigated this situation at all.
Well, I believe that in early 1987, the Drexel people advised Home Shopping, and Home Shopping agreed to reset the conversion price so that the price would be either $25.80 a share or 120% of the stock's average price from March 10th to April 21, depending on whichever was lower. Does that sound like I've got the straight of it?
That sounds right.
The claim is made that the Drexel people who received a $2.5 million fee for this underwriting never disclosed to their client that a reset without a floor being put into the reset would make these bonds, or debentures actually, an attractive investment for American arbitrageurs, thereby promoting speculation in the Home Shopping Network's stock. Is it not the common practice when there is a reset for a floor to be placed on the reset?
I'm not sure I can answer that question off the top of my head. I don't know what portion of the deals have a floor and what portion don't.
Well, it is true that Drexel did advise Home Shopping to reset the conversion price.
I believe that's correct.
And subsequently, do you know how far the price of the stock fell?
I believe the stock has recently traded around $5 a share.
Well, that's correct. It's my understanding that on April 18th, it was $5.62 a share, having fallen down from $47 a share in early 1987. Now, what does a drop like that mean to the owners of these bonds?
The owners of the convertible bonds with the reset?
That's right.
That means that their conversion feature still has a value to it. And if I remember correctly, I think the conversion feature was to be set at a premium 120 or 125% above the market price during the reset period. So it would simply mean that the bonds, which would have fallen somewhat but not that much, would have a lower conversion price, a conversion price still above the present market. And of course the bonds wouldn't have fallen as much as the stock because they had an underlying yield which had gone up as the bonds fell in price,
now,
reflecting the falling stock price.
The initial representation made to the Home Shopping people by Drexel, as I understand it, was that these bonds were for the European market. They were Euro-dollar bonds. Is that correct?
They were sold as Euro bonds.
But as an actual fact, most of these bonds were purchased by the people back here in the States who were part of the Drexel bond buying network, no?
No, Mr. Lent, I think that's not accurate. Let me put this in context just slightly. We have recently been sued by Home Shopping Center in a case which my counsel tells me is reasonably outrageous. I have not had an opportunity to review the specifics. The company's made a number of allegations, quite a few of which I gather we will disagree with in court. I'm not sure if this is a fair forum to go into that in great length, since I wasn't prepared to do so. But I, in fact, do not believe that those, let me stop for a second, step back. Those bonds were originally sold to the extent they could be sold to European investors, not to American investors. Over time, the European investors' experience was very unsatisfactory, and as the bonds traded, they were picked up once the appropriate time periods had passed by various U.S. investors. As far as I know, very few of our regular high-yield bond buyers own those bonds or owned them at any time during the period.
Well, getting back to my prior question, when the price went from $47 a share down to presently $5.62 a share, this means that the owners of these bonds are able to convert those bonds into stock at a much lower price, isn't that?
That is correct.
And and therefore they could receive many more shares at $5.62 a share than if the price were $47 a share.
They would be able to receive a lot more shares if they converted the bonds, but they will not convert the bonds until the conversion feature has value. And since the conversion feature is going to be set above the current market, they would not want to convert those into shares. They would probably rather stay in their bond position, because the prospects of this company are somewhat problematic, I think, at this stage.
Well, how do you respond to the charge that Drexel fraudulently induced or misled the home shopping network into a fraudulent reset of their conversion price?
We think that's just simply inaccurate.
And how would you explain the 40% drop in the home shopping network stock price since March the 10th, the day when the conversion price was reset?
Home shopping center stock has been extremely volatile, mostly on the upside prior to our issue, and on the downside since then. The company had great difficulty in getting their phone system set up the way they were supposed to, and I think have filed $1 billion lawsuit against GT&E over that. They are not obtaining the sales per viewer that they had projected. Their earnings have been far, far lower than the earnings they had told the investment community to anticipate. There are questions about the ability of the management to control the company and manage the company. There's a long litany of disappointments from the point of view of the investing public that I think account for the decline in the price of the stock.
So that it would be the position of your firm that the charges that are in the action, that the price of their stock has dramatically fallen as a result of manipulative short selling by those with ties to Drexel, is not correct.
That is, you are correct.
Okay.
That is not correct.
I have no further questions. Thank you, Mr. Chairman.
Chair recognizes now the gentleman from Kansas, Mr. Slattery.
Thank you, Mr. Chairman. Mr. Joseph, as I indicated to you earlier this morning, I would undertake to be as fair with you as I could be, and I would like to try and do that. And this morning, in my questions to you, I focused on the matter of BCI, and I would like to return to that if I could, because some of the answers to my questions this morning were rather alarming to me, and I wanted to make sure I understood them. And so if I could, I'd like to come back and focus on that matter. If you recall this morning, I indicated to you that we had a situation where on April the 10th, I believe it was, 1986, the subcommittee investigation identified that at least 24 insider accounts at Drexel purchased $235 million of BCI notes on the day of distribution. And on that day, United Mutual Fund of Kansas City, Missouri, attempted to complete an order and was told that in fact they could not buy as much
as they wanted to buy. And they were told this by Mr. Tobey, and our evidence has indicated that that same Mr. Tobey had a beneficial interest in Otter Creek and Financial Investments, which on that same day purchased these notes that he was telling United Fund they could not buy. And this morning when I posed that factual situation to you, you indicated that you didn't see anything wrong with Mr. Tobey's conduct in that case, if in fact that's what he did. And I wanted to come back to that point and again ask you that question and give you an opportunity to respond. Do you see anything wrong with Mr. Tobey's action in the factual case that I've just posed?
I really don't, and I understand the perception can be somewhat different as you posed it. But Mr. Tobey is the sales manager in the high yield bond department, of one of the sales managers. He was simply reporting the allocation to that account, which he had been told by whoever was the syndicate manager, I think, at the time, or acting as syndicate manager at the time. He was not determining that he was not going to let United Mutual Fund have bonds that he wanted to have for his own account in this combined partnership.
Mr. Joseph, I want you to understand, though, and I hope you do, that Mr. Tobey was telling a public customer, United Mutual, that they could not buy what they wanted.
Yes,
okay, because he would like to buy what he wanted. Okay? Now, let me make sure you understand what I'm saying, because our factual evidence would indicate that Mr. Tobey had an ownership interest in this Otter Creek and Financial Investments insider account. And on that very day, they were apparently buying some of the bonds that Mr. Tobey was telling United they could not buy.
Excuse me, Mr. Congressman, are you saying Mr. Tobey said he wanted to buy these bonds? They couldn't have it because he wanted to buy it? I mean,
the reality is Mr. Tobey had an ownership interest in Otter.
But he didn't say you can't have it because I want it.
And that firm was, that account was buying bonds that Mr. Tobey was telling United they could not buy.
I understand, and I understand the perception problem, but again, Mr. Tobey was not making the investment decisions for Otter Creek. He may well not have known that they were buying the bonds. This was part of a $2.5 billion issue.
I understand. Let me ask you this. Do you know who the syndicate manager was that Mr. Tobey might have been reporting to?
He doesn't report to the syndicate manager, but the syndicate manager keeps the book on a bond deal and makes the determination as to who.
Who is the syndicate manager?
I don't know who the syndicate manager in the high yield bond department is at that time.
Does anybody with you today know who the syndicate manager may have been?
I'm not sure, but we can find out and let the committee know quickly.
Who decided that Otter Creek got those bonds?
Yes, we will.
Second.
Who decided that Otter Creek got those bonds? The syndicate manager?
Who decided that Otter Creek was going to buy those bonds?
It would have been the investment advisor, investment manager for Otter Creek.
And who was that?
I'll have to check. The investment committee in Otter Creek is Lowell Milken and Bob Davidow.
Pardon me?
Lowell Milken and Bob Davidow, and I think at that time a fellow named Reed Harmon was also a member of that committee.
Now, if my memory serves me correctly, Mr. Joseph, on that same day, April the 10th, 1986, Lowell Milken IRA was also purchasing these bonds, $170,000 worth of them to be precise.
That's correct. I believe that's correct.
Mr. Milken is also an owner of Otter Creek.
And I would observe that Mr. Milken is also an owner of Otter Creek.
Yes, I believe.
And he was making the decision to buy at a time when he was also apparently involved in the decision to tell United not to, they couldn't buy.
No, I do not think he's involved in the decision as to which customers are allowed to buy the bonds.
Was Mr. David, who?
David Owl. The other
Owl?
David Owl.
Was Mr. David Owl?
No, Mr. David Owl, I believe, is in the High Yield Research Department.
Let me ask you one other question. What is your fiduciary duty or obligation to a long-standing customer like United Mutual? When they call you up and place an order, what is your obligation to them?
I think you have an obligation to be fair to them. And as I indicated this morning...
To fair, does that mean that when they say we would like to buy X amount of an issue, that your employees, Mr. Joseph, should undertake to do everything humanly possible and within the law to complete that order? Isn't that what that means?
I think it depends on a number of considerations. When you have an issue, whether it's a bond or a stock issue, and again, they're very different.
Okay. Let's not complicate this, really. I mean, we can, and I'm a lawyer, not as good a one maybe as a lot of in this room, but let's not complicate it and obfuscate it. The fact of the matter is, you would like your customers in this country to believe that when they place an order with Drexel Burnham, that the people attempting to fill that order are going to do everything humanly possible to fill the order. Wouldn't you like your customers to believe that, Mr. Joseph?
I think I would.
Now, the reality is, in this case involving United Mutual, that did not take place. Now, there's no way that you can conclude that it did not take place.
No, I think you're talking about different people in a department. I think the salesmen on that account probably were working very hard to do the best they could for the account.
Okay, I'm out of time, Mr. Chairman, I realize. Thank you.
Chair is going to recognize himself for some questions here. Mr. Joseph, what is the policy at Drexel with regard to insider accounts? Are they approved or are they disapproved?
I'm not sure I understand what you mean by approved.
Well, do you approve of them or do you disapprove of them as a matter of company policy?
We like our employees to have accounts with the firm if they're going to be
So you are telling me they are approved?
I guess I am.
Substantial amounts of money are made by these insider accounts, are they not?
We have a lot of employees and they have made money over the years and have accumulated capital. Yes, sir.
Would the chairman yield for just 30 seconds there?
Now, the 1938 Act requires, rather the 1933 Act requires that there be disclosures of certain events associated with the sale of securities. The first is that there be the disclosure of a plan of distribution of the securities. That would cover the distribution of these high-interest bonds. Was any plan of distribution ever disclosed with regard to any of the issues that this committee is discussing today?
I believe that the prospectuses would have indicated that we were doing a public offering of the bonds.
That was then the disclosure which was made in conformity. Plan of distribution carried out according to its terms.
I think it was.
Did the plan of distribution disclose the presence of these insider trading accounts at Drexel?
No, I don't think it would.
But in each of the instances inquired into by the committee, those insider accounts achieved
ownership of significant amounts of stock. Is that not true?
Bonds.
Of bonds, I'm sorry. And they also achieved the possession and ownership of those significant amounts of bonds prior to the ownership, or rather prior to the opportunity of others of your customers, both old and established and new, before those new or old regular customers were able to procure their full demand for securities. Is that correct?
I think in some instances, for various reasons, some customers
but it is true
not get the bonds that they indicated they wanted, apparently.
Can you explain then to me how that complied with the plan of distribution which was put forward in your prospectus?
I think that based on the plan of distribution as we went forward with the offering, the description of these as public offerings was the view as to how the bonds were going to be sold, and that the fact that some of the bonds were going to be bought by employee accounts was not a material disclosure requirement.
Now, the prospectus is also, under the statute, supposed to set forth the compensation of officers and employees of Drexel in connection with the issuance of these new securities, is it not?
It sets forth the commissions being charged the issuing company.
Was there ever any disclosure of the monies that were made by the investors in these insider accounts by Drexel in connection with the prospectus?
I think not, and I think that it wasn't necessary to make that disclosure.
Can you explain why?
Because it is not a cost to the issuing company in connection with the issuance. At the time you wrote the prospectus, you wouldn't have any idea what the profits or losses would have been from people owning those securities. And in fact, I think very often at the time of the prospectus, you wouldn't even know who the buyers of the securities were going to be. I don't think it's a practical thing to disclose, nor is it material to the other investors, nor is it of any moment to the issuing company.
You are telling me then that it is not practical to disclose that you have insider investment accounts at Drexel which are achieving ownership of securities issued by Drexel before your regular customers are able to achieve ownership of those same securities?
I don't think it's a requirement or material from the point of view of the issuing company's registration statement from the point of view of it providing accurate and complete information to the other investors.
Now, Mr. Joseph, do you regard it as fair and proper that employees of Drexel and officers of Drexel should achieve ownership of securities which are handled by Drexel prior to the time that other persons in the market are able to achieve ownership of those same securities and under terms more favorable than those other persons, both with regard to sale price and purchase price?
That would depend on the specifics, Mr. Chairman. If they were making a venture capital investment well before a public offering, that might be fine. If they were buying it moments before, I think it just depends on the specifics. I'm not sure what you're referring to.
We have discussed 3 cases, Textyrene, Hanover, 2 cases, I'm sorry, Textyrene and BCI Holdings. Are you telling me that in each instance these matters were conducted in a fair and proper fashion?
Well, I think our employees bought the securities on the same terms as everyone else at the same time as everyone else, and don't think that that was unfair.
You say that even though many of the people were not given their full access to the shares at the original offering price, while employees' insider accounts got them at the original offering price before other bidders in the marketplace were able to secure those same shares?
But again, they're not shares, they're bonds. And
I'm sorry, the same securities.
The same securities, but the important thing is they really are bonds. They're an opportunity to make a loan to a company at an interest rate that has been professionally negotiated as being the fair rate at that point in time. Bond issues goes up and bond issues go down. Your staff has picked out some issues during an explosive rise in the bond markets and makes it look as if we're dealing with a hot stock offering, and we're not. It's a very different animal.
Are you telling me then that this situation with regard to the two issues of securities was handled in a fair and proper fashion, or in an unfair fashion? Which are you telling me?
I think they were handled in a
one or the other. Which is it?
I think they were handled in a fair manner. I'm not ecstatic about the perception of the way they were handled. I'm not pleased about the perception as we're discussing it here, but I don't think it was unfair.
The perception of this committee is hardly kind on these matters, Mr. Joseph. I'm sure you understand that.
I do indeed. Thank you.
Time of the chair has expired. The chair recognizes the gentleman from Minnesota, Mr. Sikorsky.
Thank you, Mr. Chairman. I mentioned earlier in my opening statement that I'd focus on the Lutheran Brotherhood Life and the IDS issues. Lutheran Brotherhood Life was text streaming, and the IDS is the BCI. Before we go to that, you just responded to the chairman that your employee investment accounts, these so-called insider accounts, were on par with the other clients, on equal footing. In the Lutheran Life circumstance, they asked for $2 million, got $500,000, got 1/4 of their request. How much did Otter Creek ask for and receive?
I don't know, but it's possible they may have wanted more. You also...
I know it's possible. I'm wondering if, in fact, they wanted more.
I don't know the answer.
How about any of those inside account that got those bonds?
In all cases, I don't know how much they might have wanted. They may have wanted more, not been able to get it. I think the important thing to understand... Let me finish, please. Is that the process of determining which clients get how much of which issue is a very sophisticated process. We have customers in the bond market who, to test the market, will come into us and ask for 5 million bonds on a specific issue, and if you gave them the whole 5 million, they would assume that that issue is undersubscribed and may be soft, and maybe they can buy it in the aftermarket at a cheaper price, and they'll pull the whole $5 million order away from you. So you've got a fair bit of almost poker going on the trading desks between very sophisticated professionals as to how much people really want, how much they say they want. Are they testing you? Have they been a historic good buyer? Do they buy on all your issues, or do they try to pick the good ones?
That sounds reasonable to me.
Okay.
Now, let's break that sophisticated general process down to the specific case that I raised earlier. Lutheran Life wasn't testing. They wanted $2 million, and you gave them a fourth of that, $500,000.
I frankly don't know. I see this memo, and I see what the memo says.
Well, who would have made that decision as to who got what? Otter Creek got X million, and Lutheran Life got $500,000.
The Drexel professional that was quote, running the book on that syndicate account. I do not know who that was.
And you'll find that out.
We have said we will find that out and provide that.
If that person had any equity or any interest in any of the inside accounts that got that offering. Looking at changing now to the BCI issue that's been talked about before, we've got, thank you. IDS is a large mutual fund annuity and insurance group based in Minneapolis, Minnesota. Again, it's a customer of yours and a regular customer. It purchased in April, I think 10th of 1986. You did an offering, biggest so far, I think, on the BCI issue. And it had 12.5 and 12 3/4 juniors and seniors and the rest of it. And I think our information is focused on the 12 3/4 because that's most of the information we got on it. And focusing on that, you informed, we've been informed by the account managers and the console at IDS that Drexel cut back its purchases of the BCI 12 3/4 notes at distribution. According to their letter to us, IDS would have bought more notes of BCI holdings and were allocated to IDS by the underwriter, Drexel Burnham Lambert, Drexel, and had indicated its desire for a greater number of notes to Drexel. The fact that IDS was allocated fewer notes than had initially requested from the underwriter is evidenced by the fact that IDS purchased additional notes in the secondary market shortly after the initial purchases, and it paid, as I understand, 3 3/4 more, or 375 basis points as a premium for that. And Mr. Chairman, without objection, without objection, could I have this document?
Without objection, so ordered.
It's been provided to you, I believe.
Chair, apologize, gentlemen, for intruding, but here we have a very basic question. What policy do you have in the company with regard to distribution of issues of securities which are essentially oversubscribed, dealing with who gets the securities when you have more demand than you have securities, referring particularly to the distribution between the insider accounts and the ordinary accounts of the company?
We have very detailed procedures for determining on a stock issue if the issue is oversubscribed.
You're referring to stock. I'm referring to securities. And most specifically, I'm dealing with this particular issue of bonds.
Yes, I understand. My point is that the rules are written in, say, securities. The rules, in fact, apply to stocks, and on the stock side, we have very strong rules, and the way our rules work is that if we determine that a stock issue is oversubscribed, no employee accounts can buy the stock.
No employee can buy a stock if a stock issue
is oversubscribed. We don't think that those rules are intended to apply to bond issues, because bond issues don't get oversubscribed in a way that leads to a pop in the price and a hot new issue syndrome and opportunities for windfall profits, which you can, of course, get on a stock issue. So on a bond issue, when an issue is oversubscribed, the people don't come in and chase the bond up in the aftermarket. They simply find another fungible issue somewhere that they think gives them the same return that they wanted for that kind of rate and put the money into the other issue. So it's an entirely different issue. It's keeping the windfall profits from stock issues from being taken up by the officers and employees of securities firms, and we're absolutely rigid on that, as compared to bond deals, which are really quite different.
So you have no provisions whatsoever establishing an order or preference for purchase in the event that a bond issue is oversubscribed, or you have more offers than you would have securities available to sell?
I think not.
Why?
Excuse me?
Why?
Until today, I didn't perceive any need for it.
Very well. Chair thanks the gentleman, apologizes. Chair recognizes the gentleman again.
I thank the gentleman for clearing those matters up. Just briefly on the IDS issue, they purchased 12.5 and 12 3/4 of BCI on April 10th. On April 22nd, an insider account sold $6 million in 12 3/4 notes back to Drexel for 103.75, realizing a $225,000 profit in only 12 days, to Drexel for, I'm sorry, and if compounded, this would be triple the insider's investment in over a year. Only a few days after the insiders sold their position to Drexel, Drexel sold the 12 3/4 to IDS for 103.5, which again is 350 basis points more than the price IDS would have paid at the initial offering. Maybe to help analyze this, you could make a submission to the subcommittee on this issue, responding to the questions that I asked on Lutheran Life.
Okay, we'd be pleased to do that.
Thank you. And any remaining time, I yield back to the Chairman. Thank you, Mr. Chairman.
Chair, thanks, gentlemen. The Chair would like to read from a SEC ruling dated 3/16/83, entitled Trading Prohibitions. Says securities covered by Rule 10b-6, a new exception for non-convertible investment-grade debt and preferred securities. The first words of that are as follows. Historically, Rule 10b-6 has applied to distributions of all types of securities. Is that your understanding of the law, Mr. Joseph?
I rely on my counsel for that. I wasn't aware of that rule or that change.
Well, it says clearly this. Historically, 10b-6 has applied to distributions of all types of securities. What is your understanding of the law on that point?
That's a hot issue. Don't confuse it.
Excuse me, I'm going to have to consult with my counsel.
That's all right. Let me say this. Do you have any understanding of your own at this time on that particular matter?
No, I think I'm confused.
Right. Have you ever consulted with counsel on this point prior to the time that you entered this room on this point?
Yes, I have.
What did counsel inform you in those earlier discussions?
It's extremely complicated, Mr. Chairman. I'd really like to let them explain some of the differences to me.
We both have access to good lawyers.
Why don't we let them talk to each other?
Than mine, but we both have good lawyers available to us. What I'm trying to find out is if you ever consulted with them and what your appreciation and what the policy at Drexel was on this particular point. Perhaps since we have muddied this issue so thoroughly, you could just tell us what was the policy at Drexel with regard to whether 10b-6 covered all types of securities.
My understanding is that I think 10b-6 does cover all types of securities. What we've been discussing previously was the hot new issue rules of the NASD, which I do not think apply to debt securities.
Mr. Joseph, in your testimony this morning, I understood you to say that Drexel used the same criteria for deciding how many bonds employees would be able to purchase as it did for its other customers. Was I correct in that understanding?
Yes, I believe that is the way we try to deal with that.
Does that mean that Drexel accounts are allocated when an issue is oversubscribed with regard to high-interest bonds or junk bonds?
No, not necessarily.
It does not?
No. The things you would consider might include the historic pattern of the account in buying new issues, whether they keep them, whether you can, they sell them into the immediate aftermarket, whether they've given you limitations on price ideas. There's a slew of considerations that might come into effect. It is not a numerical allocation and should not be.
So you're telling me that you have rules with regard to allocations of securities where you have more demand than you have volume of securities to satisfy the demand, or you are telling me you do not?
I think rules is putting too much of a discipline on it. We have practices.
What are those practices written down anywhere?
I don't think so, except in some specific situations. For example, with respect to equity issues, we have explained to our branches.
We are not discussing equity. You have reminded me that on several occasions, and I have accepted your corrections in full recognition of my failure.
Well, we're dealing with broad parts of the firm. We very often will write the rules down, was the point I was trying to make. In the debt area, where our trading and sales desks are very centralized, it's unlikely that we would have written rules to determine how those are going to be, how the allocations are going to be made. It really depends on the client relationship and the history of the client and the kinds of, they're relatively intangible, but when you're practicing the brokerage business, these are intangibles you understand, the importance of the relationship with the account.
Then you were saying the criteria is the importance of the client and the length of the client relationship?
Those would be real factors.
That is the test?
No, among others. Among others.
Among what others?
The history of the account and buying your new issues, any price parameters the account has given you in giving you their indication of interest, the order in which the indications of interest came in might matter on a specific transaction, whether they wanted you to buy bonds back as part of the reason that they're interested in buying this specific issue, whether you know that this institution knows the account, knows the company, the issuing company, and has a long-term interest in the company, whether the account has in the past been particularly difficult or easy to deal with when issuers have needed waivers, whether you have a relationship with the account in terms of a brokerage relationship. IDS, I'd note, is owned by American Express, which owns Shearson Hamel, which might affect our judgment in dealing with them.
Well, let's take a look here, and let's just go through a couple of these. You mentioned IDS. IDS tried to procure a certain amount of BCI. They were cut back. Insider accounts secured ownership of a comfortable amount of that stock. On what criteria was BCI cut back?
Mr. Chairman, I'm not going to know the answers to that kind of question on any specific issue with respect to any specific client. I can see if our people can recollect and answer those questions. I'd be glad to do so.
Well, let's go to another. Drexel allocated United only 80% of the 12.75% notes it wanted in connection with Hanover. On what criteria was United cut back in this matter?
Well, I'd point out that 80% is a pretty good allocation in most cases, but again, I'm not going to recollect. I had no knowledge at all of how the allocations were made on specific transactions.
On what basis then were your insider accounts cut back on both the Hanover matter and the BCI matter?
I don't know that they were or were not, but the types of considerations would be very similar to the considerations.
Would they be similar or would they be identical?
Well, there's a number of subjective ones. I'm not sure I can assure you they're identical.
You're saying this judgment then was subjective?
Excuse me?
You are saying then that this judgment was subjective?
Yes, sir. I think I did say it is subjective, but subjective based on the business relationships.
We discussed the question of indications of interest. Are those written or are those unwritten?
They are generally not written.
They are generally not written. They are provided to Drexel by the purchasers?
Yes, sir.
If they are written, what happens to them?
I'm sorry, I missed the question.
If those indications of interest are written, what happens to them?
They are virtually all obtained by telephone. My guess would be that 99% of them, if not all of them, are verbal indications of interest.
Does Drexel write these down when they receive them on the telephone?
Yes, someone obviously has to keep track of them.
What happened to the indications of interest in the textstyrene issue?
I have no idea. It may have been retained, it may not have been retained.
Were they destroyed?
Excuse me?
Were they destroyed?
They're typically kept on a yellow pad by whoever is keeping the book on the transaction. Whether those yellow pads are maintained or not maintained, I don't know.
Who is it?
When I say yellow pads, it might be a form of a sheet, but it's simply scribbled on a sheet. I don't know whether they're retained or not.
They are kept on a yellow pad. They aren't kept in any formal way so that they can be used as a part of a judgmental process by Drexel in case of allocation of securities on which there's a greater demand than supply.
Well, I'm recalling when I was in the head of corporate finance department and would sit with the syndicate manager and review the book on a deal, he typically had a yellow pad, so I'm visualizing a yellow pad. They may, in fact, be kept in a more formal format. I simply don't know the answer to your question.
Well, I'm trying to figure out how these indications of interest get into the decision-making process as to how the shares, or rather as to how the securities shall be allocated amongst the several would-be buyers. You have indicated that a subjective procedure is followed here. I am trying to find out how the indications of interest play a part in this allocation of issues of securities which are in practical effect oversubscribed.
Well, whoever is acting as a syndicate manager will look at and keep tallying up the indications of interest. Very often they'll note that they don't believe they're real, or they have price limits on them, or that this institution has not actually followed through on a majority of their recent indications of interest to us, or that they think this institution may have given this order to several securities firms simultaneously. So we try to make a judgment in the poker game of understanding where the market is as to how real the indications are, at what price, how will today's market conditions affect those indications. You may get indications over a week period leading up to an offering, and during the first 4 days the market was rising and everyone's coming in with very large numbers thinking they're going to be cut back and trying to get as much as they can. The market turns down, you then give them what they asked for, and they laugh at you because they really didn't want it and certainly don't want it in the declining market. So there's a great deal of judgment involved in determining which of the orders you're going to fill, to what extent are you going to fill them, are they good at this price, and will they actually close on the delivery date.
Now, do you know Lorraine Spurge at High Yield?
Yes, I do.
She is one who takes these indications of interest and keeps one of these yellow pads that you have been describing to me, is she not?
She's one of the people who does it.
She belongs to one of your insider accounts, most specifically financial investments. She is one of the beneficial owners of this institution. Do you regard this as in any way a conflict of interest, or imposing upon Ms. Spurge the responsibility of making judgments which may impose a conflict upon her between her personal interests as members of this particular investment group and the other clients of Drexel?
It could potentially create a conflict of interest, although I would be interested in knowing the size of her ownership in there as a percent of that partnership as compared to her other compensation matters. I also know that these decisions are not made by one person, but reviewed by other supervisory people in the department.
She is also listed as a beneficial owner of Otter Creek Associates. The same question, does this impose upon her a conflict between the interests of the clients of Drexel and her personal interests?
It could potentially, and again, it would depend on the materiality of her interests.
They are both owners of Otter Creek.
Now, Mr. Brown and Mr. Lowell Milken make the allocation decisions with regard to securities which are essentially, again, oversubscribed, on which there is greater demand than there is supply.
No, sir.
Does this constitute a conflict of interest on the part of either of these gentlemen, Mr. B. Brown or Mr. L. Milken?
No, sir? Mr. Chairman, I think not. I think they are on the investment committee.
They are on the investment committee
of Otter Creek. They are not the people that make the allocation decisions.
Who makes the allocation?
Who then makes these allocations? Who is in charge of the decision?
It would be the syndicate person. Lorraine Spurge is one of them.
Lorraine Spurge then is one of the syndicate persons.
Yes, she
Who are
is.
the other syndicate persons?
I don't recall their names, but I could.
Would you submit those names to us, please?
Yes, we will.
She makes the decisions.
Pardon?
She makes the decisions, and she's making the decision what goes in her own account, Otter Creek.
So it is plain that Ms. Spurge participates in at least two decisions. One is what goes into her own account, and one is what items, or rather what allocations of the securities are made to the regular customers of Drexel.
I don't think exactly. She is not on the investment committee of these funds and does not determine which securities the funds want to buy.
She participates in the allocation.
She does participate in the allocation.
I didn't say she made the decision alone, but she participates.
All right, I misunderstood.
Now, are the others on this committee also persons who have a beneficial interest in the insider accounts?
I don't know, because I don't know who they are. We will check and find out who participates in the syndicate decisions and whether or not they're members of the partnerships that purchase securities in situations where they were managing the books.
Are there any rules at Drexel with regard to the behavior of persons who are charged with the responsibility of making allocation of these securities amongst the several bidders?
I'm sorry, yes, I don't think I understand that question. Could I hear it again?
What I'm trying to find out is what are the rules that bind the individuals who make the allocations of securities amongst the several would-be purchasers to assure that there is no conflict between their personal interest in some insider account and their responsibilities to Drexel's customers?
I don't think there are specific rules dealing with that specific item.
Are there any rules?
Well, we have a code of conduct for our employees, and we think...
What part of the code of conduct deals with these matters, Mr. Joseph?
There are a number of parts of the code of conduct that deal with fairness and professionalism and the importance of the client relationships.
What part deals with the behavior of persons in these positions? Can you inform us what part it might be that would dictate how they would behave in these matters?
I just think of the overall code of conduct for our business and the firm's published code of conduct. I don't think there's specific treatment of the allocation process on underwritten bond issues.
We have here a situation, let us just take the case of Ms. Spurge. Ms. Spurge is one who receives the indication of interest and puts them on a yellow pad. Ms. Spurge is one who, together with others, whom you cannot name to us at this time, who makes decisions on what account gets what allocation of securities. Ms. Spurge is an investor in Otter Creek and in Financial. Ms. Spurge then makes decisions which can benefit her own account over the public clients of Drexel. Ms. Spurge has, you tell us, no specific instructions as to how she is to deal with these conflicts. You inform us that this is under Drexel's Code of Conduct, but you cannot tell us what portions of Drexel's Code of Conduct control this behavior or how they would dictate any guidelines for behavior to Ms. Spurge. Does this strike you as peculiar?
I didn't think you said that.
Mr. Chairman, I think we've built ourselves a case which clearly is some discomfort to me, but the fact is that if we go back to the earlier parts of our conversation, we're talking about new issues of bonds, which reflect an opportunity to make a loan to a company at a interest rate that has been professionally negotiated. Interest rates rise and fall. It is not as if we're giving someone the opportunity, the key to the safe, or the opportunity to get the windfall profits from new issues. On the Beatrice issue, for example, it was a $6.5 billion transaction involving some of the most sophisticated financiers in the country. The banks lent, I think, 3 to 4.
Some of the most sophisticated financiers in the country got significantly worse conditions on their purchases and on their sales with Drexel, the sole market maker, than did the holders and the beneficial interest holders of these insider accounts. How is this to be explained?
I think there are cases where they've gotten better terms than our people. I think we've got
that can be explained.
Single case.
That can be accepted with some comfort by these outsiders. How will they accept the fact that they got lesser prices on sale and higher prices on purchase than did the insider account owners at Drexel?
I think you've really got two different issues. One is they know the market when they buy and sell these issues. The new issues.
Were any of these facts with regard to the insider accounts disclosed in any of the prospectuses or in any of the filings or reports which were submitted either to the public as a part of offerings or as a part of the requirements of NASD or any of the exchanges or the SEC by Drexel?
I think some of them were disclosed after the fact as required, as appropriate. I don't think they were required.
Could you submit to us any disclosures of this kind?
I will endeavor to do so, yes,
either in the prospectuses or in the reports which were filed with NASD, with the exchanges, or with the SEC, please. And without objection, the record will remain open for those reports of disclosure to be submitted by Drexel. Now, the chair has consumed as much time as is appropriate now, and the chair will recognize my friend from Oregon for further questions.
Thank you, Mr. Chairman. It seems to me you've made a number of very important points, and certainly what I was concerned about when we started 6 hours ago is clear. The simple fact is not all junk bonds are created equal, and we have seen the consequences today for a number of investors. Now, I'd like to look at just a couple of other lines. One, Mr. Joseph, it's my understanding that Dennis Levine and Martin Siegel owned insider accounts at Drexel Burnham, and one of those accounts was financial investments. Are you at all familiar with that account or that partnership?
I'm sorry, I didn't hear the end of the question.
Are you familiar with that particular, we would call it insider account, you would call it an employee account?
I'm aware of that partnership.
What information do you have concerning how Mr. Siegel or Mr. Levine got involved in financial investments?
They both would have become involved in that when they were professionals at Drexel Burnham in the corporate finance department prior to our learning of their violations of various security laws and prior to our terminating our relationships with both of them.
And what transactions were they involved in as owners of those accounts?
I cannot recite the transactions of those accounts. I don't know what they were.
You have no information on their involvement in those accounts at all, then? With
I don't have any with me. They were not on the management committee or investment committees of those accounts. They were simply limited partners, passive investors in those accounts.
Mm-hmm. I want to ask you about one other case which strikes me as yet another group of investors that came up short in the way business was done at Drexel. The subcommittee talked recently with Earl McAvoy, who's a portfolio manager for Vanguard High Income Fund. This is part of the Vanguard family of mutual funds. They have over 3 million shareholders. Mr. McAvoy works for the Wellington Capital Management Group. They manage the fund for Vanguard. Now, Mr. McAvoy told the subcommittee that on February 11th of 1986, Mr. McAvoy purchased $750,000 in textyrene notes at 98.5 from the company. Mr. McAvoy stated, and I quote here, "I'm absolutely sure we ordered more than we got of the textyrene notes on February 11th. Mr. McAvoy also stated that it was Vanguard's normal investment practice to take 10% of such issues. Mr. McAvoy went on to tell the subcommittee that Vanguard filled our order after the notes were issued. This took place on February 19th when Vanguard purchased an additional $4,250,000 of the notes at 101.75. That was a premium of 350 basis points over the February 11th price. And this purchase then brought Vanguard's holding to 10% of the overall amount of textyrene notes issued. Mr. McAvoy then told the subcommittee, and I quote here, "Our account manager at Drexel was Mark Chasen. I would have ordered from him. He would have told me we got only $750,000 and that we did not get our whole indication of interest." Now, there were additional documents that had been given to the subcommittee, and in these additional documents, they show that Mark Chasen was an owner of at least 5 insider accounts, including Otter Creek and Financial Investment Associates, which bought $4 million and $3 million, respectively, of the textyrene notes on February 11th. Mr. McAvoy and the Vanguard researcher, who also analyzed textyrene for Vanguard, stated that being allocated only a portion of their desired purchase confirmed that the security was a good investment and that their research had been correct. As a consequence, they continued to be interested in buying in the aftermarket, although the security went up in price. Mr. Joseph, this case shows, as so many of the other cases, that any way you slice it, the people on the outside aren't getting the same terms as the people on the inside. How could one possibly see it otherwise?
Well, our conversations with our people indicate that the textyrene issue was not a heavily oversubscribed issue. I admire Mr. McTeague's work in finding people that apparently were cut back. I don't know the details of the again, the reasons for Vanguard's being cut back as much as they were.
But the countryside is now strewn with your clients who say that they have not been able to order as much as they wanted.
We're still talking about 2 issues out of 300, out of
we now have
13,
Minnesota,
700.
Minnesota, we have Kansas, now we're going to Boston. The list goes on and on.
No, but you're still talking about 2 issues that happens that there are institutions located in lots of different states.
We've spent some time trying to get the bottom of these 2 issues, and frankly, I'm not at all convinced that we're there yet. But certainly we are talking about some significant investments. Now, is there any possible explanation for what happened to Vanguard as particularly related by the manager, Mr. McAvoy, other than what I've said, that they simply were not given, as an outside client, the same arrangements that people on the inside were?
Congressman Wyden, first of all, this is the first I've heard of this and have seen this statement. Secondly, it seems to me that Mr. McAvoy is saying that he thinks they normally would have gone out and bought more.
He said, I'm absolutely sure we ordered more than we got.
But we don't know how much he ordered, and we don't know if he followed his normal practice of buying 10% of an issue. I think, I shouldn't guess. I suspect if we get our people and they can recall, and his traders can recall what went on, we might get a different recollection, a different story. I simply don't know.
I asked early on, really a question, where the SEC was during the course of all these transactions and Textyrene and BCI and the like. I think now what I'd like to ask is a different one, and that is, has the SEC contacted you at any point about the propriety of the transactions the committee is looking into today? And if so, what was the nature of those contacts?
I've been advised that the SEC has had the trading records of these partnerships and has reviewed them and has not come back to us with any additional questions. Is that correct? We think that's the situation.
There is then at the Securities and Exchange Commission no ongoing civil or criminal inquiry with respect to any of these matters? Mr. Fleming?
If I could, the Securities and Exchange Commission has only civil jurisdiction.
That's why I asked. With respect to
a continuing investigation by the SEC.
Is there a continuing inquiry by the SEC on the civil side with respect to these issues the subcommittee is examining today?
I can only say, Mr. Wyden, that all of the trading records of the partnerships have been submitted to the Commission. The Commission presumably has examined those records, and they have not asked us any of the questions that you are asking today.
Have they asked any questions about hot issues, particularly Textyrene or BCI?
No, sir. It was not until today that I heard of these 3 customers which have been referred to during the course of this hearing, either from this staff or from anyone else. Only today.
And you have heard from the U.S., you have not heard from the U.S. Attorney on the criminal side with respect to any of the transactions we're talking about today?
I have to repeat, Mr. Wyden, today is the first time in any forum that I have heard, or Mr. Joseph heard, about these 3 clients in 2 transactions.
And at this point, the company plans no change in policy. As I understand it, with respect to Mr. Eckhart's question, he asked you this specifically, you plan to review this and make a decision sometime in the future, but at this point, you do not think what you've heard up to this point warrants a change in company policy. Is that correct, Mr. Joseph?
No, I think I said that I would like to consider what we've heard and review it with our staff and our people. I've not made a judgment that it does or does not deserve a change in policy. It may well deserve a change in policy. I don't think that this is the appropriate forum for me to make that determination without further consultation with my people in New York.
Thank you, Mr. Chairman.
Sure, thanks, gentlemen. Mr. Joseph, you've indicated that you have a regularly constituted committee inside of Drexel for purposes of allocating securities amongst several purchasers when there is greater demand than there is supply. Is that correct?
No, sir.
You do not?
No.
What do you do? Set up ad hoc committees, or how are these securities allocated amongst the several would-be purchasers when there is greater demand than supply?
It varies by department, and I'm not aware in detail how the various product departments make the allocation decisions. But usually it requires input from a number of different people. We usually require input from the trading desk, from the sales staff who are dealing with the various customers who are giving the indication of interest, from the syndicate desk who will have the indications from other firms, from the corporate finance people who may have views expressed by the corporate client that they want their issue.
I've not asked how. I've asked who.
I'm describing the who in a generic sense because I cannot describe them by name specifically.
Would you submit to us the names of each person in each of the several departments of Drexel who makes the allocations of securities, both in the course of regular business and who makes it in instances where there is a greater demand for securities than there is a supply?
Yes, we can do that.
Without objection, the record will remain open. Mr. Joseph, you indicated to the committee earlier that your employees have bought into 7% of the IPOs. Of that 7%, how many of these issues did Drexel make a market in?
First of all, Mr. Chairman, IPOs usually refers to initial public offerings of stock. It's a term of art in our business.
I used the wrong term again. You have my apologies.
Mean stock. We're talking about new debt issues. I would believe that Drexel probably has made a market in virtually all of these new issues, new debt issues.
Say that again, please. I didn't hear you. I'm sorry.
I believe that Drexel probably makes a market in virtually all of these issues that we have acted as a managing underwriter, although I should point out that we are not the sole market maker in many of them, probably not the sole market maker in most of them.
Now, have you ever consulted with your bond counsel regarding the applicability of 10b-5 to these high-yield securities?
I'm sure our staff has from time to time.
And have you ever done so with regard to these insider accounts?
I believe there have been conversations between members of our firm and our outside counsel regarding employee accounts.
What were the results of those conversations? Were you told, was Drexel told that 10b-5 is applicable to these insider accounts?
Purchasing and distribution and selling soon thereafter.
We're talking about purchasing, distribution, and selling soon thereafter.
I can't answer that in a...
What you're telling me is you don't know.
In that form, I don't really know. I'm sure there have been extensive conversations,
Was
but
there any
can't...
writing submitted by the bond counsel with regard to applicability of 10b-5 to these insider accounts as regards both purchase, distribution, and selling shortly thereafter?
I don't know.
I don't know.
You don't know whether you got a written opinion on this?
No, sir.
What would be the same question with regard to 10b-6? Has opinion of the bond counsel ever been sought with regard to applicability of 10b-6 to insider accounts, including purchase, sale, distribution, and sale shortly after purchase?
I'm sure there have been discussions about
Was
those
there
items.
any writing on this point?
I don't know, but we could find out.
Would you submit whatever written opinions you have with regard to applicability of 10b-5 and 10b-6 from your bond counsel to the committee, please?
Yes, we will.
Now, Mr. Joseph, on October 27, 1987, the New York Stock Exchange asked Drexel to identify the owners of over 40 insider accounts. Has Drexel responded to that request by the New York Stock Exchange?
I don't know the answer to that question. I can find out.
It is the committee's understanding that you have not so responded. Why have you not responded?
I didn't know the request had been made. I didn't know that we hadn't responded, and I don't know why we haven't responded, Mr. Chairman.
Would you submit to the committee the communication from the New York Stock Exchange and the name of the person who has been handling this matter inside Drexel, please?
I would. I'd also like to include in that submission an explanation as to the reasons for the conversations and negotiations with the exchange, why we haven't responded, and our
Chair will be
schedule
happy to receive
for
those.
responding.
I think that might be useful. I hope you have a good explanation.
I do too.
Mr. Joseph, we have been looking again at Lorraine Spurge, and I must concede to you that our humble efforts are probably not up to the needs of the day. And I think parenthetically we should apologize to Ms. Spurge for singling her out from amongst so many beneficial owners of these insider accounts. We've discussed already her interest in Otter Creek and financial investments. On a quick and cursory review, we find that she also is a beneficial owner in South Saxony, Raleigh Investments, Bi-Coast, First Stratford, West End, and Wilshire First. Does the fact that she owns a total of 8, 6 more than we have discussed earlier, indicate to you that there might just be some kind of conflict of interest here?
No more or less than 2 would.
We find on a quick and cursory review, and I must observe this is quick and dirty work, we find 35 insider accounts. We find at least 151 Drexel employees in them. We find 10 members of the executive committee. Actually, these, and 3 members of these are members of the board of directors. These accounts put together almost $250 million for a single deal. That's BCI. One account, Otter Creek, has held at one time over $145 million. Does this give you any concern that there might be some kind of conflict of interest here between Drexel's employees who are allocating these securities amongst your regular customers and at the same time receiving them for their own accounts and their own economic benefit?
I think that's been the subject of the whole day's conversation, and the perception of a conflict is troublesome. I should point out that I'm sure you have not found the names of 10 members of the firm's executive committee in those accounts, because I'm pretty sure that the only members of the executive committee that are in those accounts are the 3 we talked about this morning.
I've been corrected by counsel here. It's 10 board and 3 executive committee members.
Okay, and that's the board of the subsidiary.
That's boards of subsidiaries.
Yeah.
But
they, in most instances, make the decisions with regard to allocations, or at least participate in them, and you will observe that they also do pass these securities back and forth, because an executive committee in one of your subsidiaries would not necessarily limit its investment interests to a single, rather to the products which were handled by that particular subsidiary, would it?
I think as a practical matter, virtually all of the activities we've talked about today are in the securities firm, which is one subsidiary.
Now, let us address another question here, Mr. President. Let us discuss compliance, if you please. Does Drexel Burnham Lambert maintain a compliance program to oversee or review securities traded by employees?
Yes, we do.
What are the names of that committee?
Oh, committee might be the wrong word. We have a legal and compliance department.
So you don't have a committee. You have a legal compliance department.
Yes, sir.
Under what charge do they operate? Do they have written rules? How do they proceed, and in connection with what matters do they proceed, and in what fashion?
They're charged with seeing to it that the firm's employees act in compliance with all the applicable laws and regulations.
Do they function under any written orders, instructions, or code?
I'm not entirely sure if there's a written... I'm having trouble answering that question. I don't know if there's a written directive as to what they do, but we all understand what a compliance department does in a securities firm, and it's to see to it that all of the rules of the exchanges, the SEC, all the laws are complied with.
Would you submit to us the names?
I'm sorry, we do in fact have a legal and compliance manual.
Would you submit to us the names of the people who hold responsible positions in this structure and their functions, please?
Yes, we will.
Would you also submit to us any orders or instructions that they have, or any rules of conduct that they comply with or carry out, please?
Yes, we will.
Would you please inform us of any actions taken by this body in the past 2-3 years, please?
Yes, we will.
And would you give specific attention to their action in reviewing securities traded by employees of Drexel?
Yes, we will.
Mr. Joseph, how would you describe this program for the subcommittee? What does it do? Who functions? And is it one unity, or rather is one entity for the entirety of Drexel, or is there a different one for each of Drexel's subsidiaries?
Well, for these purposes, I think if we consider Drexel to be the securities firm, which is Drexel Burnham Lambert, Inc., we'll cover all the items of interest.
So this body functions on a firm-wide basis, dealing not only with Drexel, but also all of its subsidiaries, or does it limit its activity to some parts of Drexel's activities?
No, it covers Drexel and all of its subsidiaries.
And all of its subsidiaries?
I believe so.
You believe, or you know?
I believe so.
See, I believe in the Almighty.
I think so, also, if that's helpful.
But I never met him, and I never shook his hand, and I've never seen him. But I got a strong belief. And so you are functioning on belief as opposed to knowledge.
I'm saying I think so. I'm not absolutely positive.
Does the compliance department in New York review on a daily basis the trading and accounts of employees?
Yes, it does.
It does?
Yes, sir.
On a daily basis?
I believe it's done daily.
Believe or no?
Think it is done daily. It is supposed to be done daily, and I think it is done daily.
Does that include trading by employee-related investment entities?
Yes, it
these
does.
insider accounts?
Yes, it does.
You know, or you believe, or you think?
It should, and I think it does.
What can you tell us about the process for reviewing the trading in insider accounts? What transpires here? Who does it? How is it done? Under what criterion does this functioning take place?
There is a list of the areas of principal attention that the compliance staff goes through as they review the employee accounts. They do a daily review of all trading and employee-related accounts. It's essentially a next-day review of special computer reports, which we call exception runs. They do a daily review of all trading and securities on the restricted list and the monitor list. They look at a 35-day history of securities on the monitor list at the time, going back from the time they're placed on the list. There's a new account run to review initial transactions for all accounts. They look at low-price securities run to review buildups of $2 and $3 stocks. They look at all of the specialist securities, securities in which Drexel is acting as a specialist, and our employees are precluded from trading in those securities. They have a 48-hour run tied to research reports, which is designed to prevent employees from front-running research reports. We have an active account report on a monthly basis, which will look at any accounts where there are more than 12 transactions in a month or more than $2,500 in commissions. They look at a discretionary account run regarding accounts over which the employees have discretion. There's an option surveillance run review, and then they do a concentration run regarding regulatory and margin requirements.
Gentleman from, I'm sorry, go ahead. Chair is going to yield the gentleman from Oregon.
No, he's not the gentleman.
One last question, if I might, Mr. Chairman. Mr. Joseph, who is the general counsel for the company who advised on the propriety of arranging for the partnerships?
Well,
is that Mr. Chasen?
No, I don't think Mr. Chasen's the lawyer.
I'm sorry, Mr. Kasparian.
Mr. Kasparian is the general counsel of the firm, the house counsel, and secretary of the corporation. Cahill Gordon act as our outside general counsel.
But Mr. Kasparian, did he advise on the propriety of how the partnerships were set up?
I don't know if he functioned on that specifically, or someone who worked for him did, or if there was...
But he handles the company's legal work inside?
He does.
Okay. Is he a member of any of the partnerships himself?
No, I believe he is not. I think he is not.
Are you certain of that? I mean, obviously, my concern would be that if he was advising on the legality and then was a partner, that would raise questions of a conflict nature with respect to compliance.
I think he is not. We can check. I've got a new word, Mr. Chairman, for whether I believe or think, and I think my new word is I'm informed.
That, it seems to me, is fair, and we would like to have that supplied for the record. Thank you, Mr. Chairman.
Without objections to order. Mr. Joseph, is trading in securities by Concordia monitored by the Compliance Department?
Yes, I believe it. I think it would be monitored. It's an employee-coded account.
Has the Compliance Department ever advised you personally, or if you know, others in authority within the firm concerning trading by Otter Creek?
I'm not sure I understand the question.
Has the Compliance Department ever advised you personally of any problems with regarding trading by Otter Creek?
Not that I recall, although I'm sure they know that Otter Creek is an employee-related account.
Has it ever advised you or any other person in authority with regard to trading by Concordia?
Not that I can recall.
Have you ever had any discussions with the Compliance Department about trading in any securities by Otter Creek?
Have I ever had any discussions?
Yes. Initiated either by you or by them?
trying to recall, Mr. Chairman. I think there may have been some conversations at various times when a registration statement was being filed that was going to show Otter Creek's position in an offering, in a security that was required to be disclosed. I cannot recall any occasion when there was any problem brought to my attention with Otter Creek, but I think there have been some conversations about Otter Creek from time to time.
What securities were the subject of this discussion by Otter Creek, or rather by the compliance department at Drexel?
I don't recall. I'd have to go back and check my records and chat with the people in the compliance department.
Was it Otter Creek? Was it Otter Creek?
It could have been Otter Creek, or it could have been Concordia, or some of the other partnerships.
But you don't remember which one?
No, sir.
Was there any written report on this matter?
I don't recall ever seeing a written report regarding the partnerships.
Has the compliance department ever submitted to you any written report on any questions that existed with regard to insider accounts at Drexel Burnham?
Well, there have from time to time been problems with various employee accounts. I don't recall any problems with regard to the partnerships, but with other employee accounts, in a securities firm our size with 10,000 employees, we regularly is probably the wrong word, but from time to time, we'll have a situation where someone traded in a restricted stock that they shouldn't have, and we have to unwind the stock or penalize them or report them to the appropriate regulatory authorities, or someone, there are a number of potential violations, and from time to time violations are brought to my attention.
Is this done in writing, or is this done over the telephone, or is this done in person? How do they communicate with you with regard to problems which exist with regard to either insider or other employee accounts?
In any of the three ways, depending on the severity of the problem and the situation.
There was a problem with a question concerning whether Otter Creek should be a partnership, or Otter Creek's position should be disclosed in a prospectus. This can be submitted for the record. The name of the security.
Was there ever any question raised with regard to whether or not there should be disclosure of any of the insider accounts or other employee accounts with regard to prospectuses?
I believe there have been such issues discussed with counsel on a transaction-by-transaction basis.
What were the accounts, or what were the securities?
I'm going to have trouble recalling them. I think I could provide you with a list that'd be more useful. Some names pop to mind, but it's a very much a random recall.
What comes to mind, sir?
I can't think of the name of the company. There was a company in the sporting goods business.
In the sporting goods business?
Yes, sir. With some conversations with some of my associates, I'd be able to get that name back out. Harris Graphics, I think, we've had some conversations about disclosing the positions that were held. I think there were conversations in connection with E2.
With regard to what?
E2. It E2? Came out of the Beatrice transaction.
What were the questions there, please, sir?
It just, that there were going to be disclosures of holdings by the Drexel employees, partnerships, in the prospectus for subsequent offerings for the companies.
Should be disclosed in the prospectus.
Yes, sir.
Why was the question of whether or not this disclosure should take place in the prospectus?
It was a legal requirement, so it should be disclosed. Farley was another one that comes to mind.
Was it disclosed in the prospectus?
If we were advised that it should be, it was. In many of the cases, I think it was. I'm sure it was.
Well, but was it disclosed in the prospectus?
Yes, where appropriate.
It was?
Where it should have been, yes.
Why was it disclosed in the prospectus?
Because you're now talking about an offering for a company where Drexel employees have a position in the company's securities or the securities that are being sold. and it's required under the registration requirements for the securities.
In other words, if you had a position in the securities, you felt that you had to disclose this in connection with prospectus on the issuance of securities. Is that correct?
Yes, if appropriate. If they were a selling shareholder, they clearly would have to be disclosed. If they had a position above a certain size based on the requirements, it may have to be disclosed. We have, on every public offering, we have outside underwriters counsel. The company always has special counsel, and it would, where appropriate, be a topic of conversation between our counsel, company counsel, our professional staff, and the disclosures were made where they were appropriate and where they were required.
Do you know how many of these insider accounts that Mr. Michael Milken has beneficial interest?
No, I don't.
Do you know how many he does not?
No, I don't.
Do you know of any in which he does not have a beneficial interest?
He would not have a beneficial interest in the advisory, the investment accounts where the members were members of the corporate finance department.
Would that be the only one?
As far as I can recall, yes, I think so, although I don't know if he's in all of the high-yield bond partnerships or not.
Why is this not disclosed in connection with the prospectuses with regard to the issuance of these high-yield securities?
Why isn't what disclosed?
That he has an interest in all save one, or approximately all save one.
Well, there's several corporate finance partnerships. Prospectus discloses information concerning the issuer. And if they have a position in the securities of the issuer that should be disclosed, it would be disclosed. If not, it's not relevant or material to an investor.
Returning to the discussions you've had with regard to the insider accounts, have you ever had any discussions with the compliance department regarding trading in securities by Otter Creek?
Trying to recall specific conversations, and I frankly can't, although I suspect I probably have had conversations with the compliance department regarding Otter Creek.
Can you recall what was the subject of these discussions, or why they were held?
No, I can't. I'm generally aware of Otter Creek. It's a substantial fund and is invested in a number of transactions. I can't recall any specific conversations about Otter Creek's investments.
Have you had ever any discussions with the compliance department about trading in any securities by Concordia?
Again, I think my answer is that I'm sure I have, but I can't recall the specific conversations that I've had with them. Concordia is a corporate finance account, I believe, and they're almost. The best way to explain it, I think, is there must have been times where I've discussed it with the compliance department, but the issues were not important issues that that come to mind at the moment.
Mr. Chairman?
You say that Concordia is a corporate finance account? What does that?
I think the employees in the Concordia account are members of the corporate finance department.
They're members of the corporate finance department. Does each department have its own insider account?
No, sir.
They don't?
No.
What ones don't?
Most of them don't. Those departments where the individuals have accumulated substantial net worths, primarily the high yield and the corporate finance department, are the departments that typically have these investment partnerships.
Thank you. Chair yields the gentleman from Oregon.
Mr. Chairman, I gather that Dennis Levine was a former partner in Concordia Investment. Do you know anything about his involvement?
Well, I know he was a former officer of our firm and was in the corporate finance department, and as such would have been a passive investor in Concordia. And when he got in trouble and was terminated from the firm, he would have been forced to withdraw from the partnership.
I wanted to ask about one other set of individuals who seem to be concerned about how they were treated. Now, the subcommittee talked with Kevin Perry, a senior vice president and portfolio manager for Barings American Asset Management, an investment management company in Boston. Now, they handled the purchase of $2.5 million in BCI 12.75 notes on April 10, 1986 for a number of clients, again from different parts of the country: GM Pension Plan, GTE Pension Plan, and Tufts University Endowment. Now, the total purchase here was $2.5 million, and Mr. Perry told the subcommittee, we got cut back, no question. We didn't get our full allocation of that 12.75% issue. Perry stated he didn't remember the exact amount he had ordered, but he believes he received in excess of 50% of what he indicated an interest in buying. According to Perry, Carl D. Reamer was the Drexel salesman who handled the BCI sale to Perry's clients. Now, Mr. D. Reamer, according to letters to the subcommittee from Drexel's attorneys, works with the Drexel High Yield Department in Beverly Hills and is an investor in Otter Creek, an insider account which purchased $9 million and $20 million respectively of 12.75% and 12.5% BCI notes on April 10th. Now, Mr. Perry told the subcommittee that neither Drexel nor Mr. De Reamer has ever disclosed to him that they had had any interest in an account which purchased securities at an offering in which Barings clients received less than they wanted. Now, I think that this is about the third case I've gone through, and a number of my colleagues have gone through other ones, and I would just ask the same question. Is there any explanation for something like this other than people on the outside are not afforded the same thing as people on the inside?
I think we've really discussed this probably sufficiently at this point in time. This, again, was a $2.5 billion issue. I'm not familiar with the individual account. I don't know what their history of purchasing has been, whether they were a client that made investments or simply traded these issues. I have never traded a bond in my life. I can't answer the questions with great specificity regarding the individual accounts.
Well, I just find this point that you've made several times, that this is statistically insignificant in your view, to miss the boat completely. To me, it's a basic question of fairness. I mean, these are citizens, these are investors who are entitled to a fair shake. And the pattern that has been developed by this subcommittee raises very serious questions in my mind about whether they've gotten a fair shake. I mean, that chart we had up there took one day, just one day involving Otter Creek, and even Otter Creek was told a price, it was 101.5, and then were allowed to get it at 106.5. I mean, these are substantial questions of basic fairness, and I hope at the end of today's session that you don't think that somehow this is something that's statistically insignificant and something that Congress is not going to be concerned about. I think it raises basic questions of fairness and whether investors are getting the fair shake in the market they ought to have. Mr. Fleming, did you want to add something on that case? Or?
Only that we have just been advised of these 4 customers who advised your staff that they believe that they were cut back. I think in all fairness, we should have time to look at the situation ourselves.
No one questions that, But frankly, given the number of people that were involved, the number of people involved in Otter Creek, the number of people involved in Concordia, it would seem to me that if the company was as vigilant and was concerned about proper procedure and propriety, as you all have said, you would have known about some of these things and could respond in some detail as to why you somehow think that there's nothing odd or extraordinary about it. But we will await to hear your comment about why these things took place, since you have said that you've heard them for the first time today. And I will just tell you it raises very substantial questions of basic fairness in my mind. Thank you, Mr. Chairman.
Time of the gentleman has expired. Gentleman from Florida.
Mr. Chairman, thank you. Just very quickly, one particular point. Going back to the employee accounts, Mr. Joseph, have you ever been a member of any of those employee accounts, investment clubs, Call It What Will, insider clubs? Whatever.
No, I have not.
You never have. I think you testified previously it's basically high-level people who make up those groups, those clubs?
Well, everything's relative. They are professional people in the firm, but they are typically not people involved in the senior management of the firm. The exception is the two senior corporate finance officers who become senior members of corporate finance since they first went into these partnerships.
Well, Mr. Milliken was involved. Mr. Milken was involved in most of them, right?
Yes,
and he certainly is a senior level.
Well, he's a very important department head, but at the firm policy level, there's a group of 8 people that meet every morning that pretty much sets the policy for the firm. Only one of those people is in any of these, and that's Mr. Batchelor, who today runs the corporate finance department.
Yeah, but it seems to me that there have been occurrences and things happening that the people who, quote, run the firm have not been aware of. I mean, we've seemed to have had testimony to that effect here, so I'm not really sure how consequential that is. Well, now the high level, low level, the secretaries, the clerks, the people maybe in a rung above the secretaries. 5 minutes couldn't have gone by so quickly, Mr. Chairman. But are they given an opportunity to join any of the investment clubs?
Not these.
I mean, it sounds to me like these people are making money. Did the regular workers have an opportunity to?
Not in these investment partnerships. Remember, the investment partnerships were formed to create an opportunity for people who had accumulated fairly substantial net worths to put their investments into a place where they would not have to be spending their own personal time watching them, which often is a problem in our industry. So for people below the fairly highly compensated levels, we have not made these partnerships available to them.
But who has the company determined the criteria for joining these groups?
The company, in conjunction with the department heads, yes, sir.
I see. So it's not only an allowable practice, it's an encouraged practice, apparently. Encouraged by the company.
Approved, I think, might be a better word than encouraged. We don't encourage people to go into them. We don't tell them we think they should or anything of that nature. But we don't disapprove of it. We think it's, in fact, a good idea from the firm's point of view.
So there's the company has established a particular net worth below which person could not qualify to even apply to be a member of the group?
Well, remember, the firm has 10,300 employees, and I think I was informed today by someone on the panel that there are 135 people in these partnerships. So it's a fairly limited thing.
Yeah, it sure is. Okay, but the company is there a particular investment amount that is basically part of the criteria for joining? You know, a certain amount, $1 million, $500,000?
I doubt if it's anything like that much. I don't know if there is a minimum number or not. If there is, I'm sure it's relatively low. not of that order of magnitude.
Have you run into any problems with any of your employees who maybe feel they're left out?
Not particularly.
Any instances where someone has maybe complained that they're not getting the opportunity to make some money, you know, on an equal basis?
When you run a securities firm the size of ours, you'll find that occasional jealousies arise from all directions. So I'm sure there have been occasions like that.
Have any of these employee groups ever lost any money?
Excuse me?
Have any of them lost any money?
I don't know. I'm sure they have in particular investments. In aggregate over a period of time, I don't know.
I see, but there have been instances when the group as a whole has lost money for particular
yes, sir. Well, they've
investments.
made bad investments. I'm sure
Thank you,
that
Mr. Chairman.
Sure, thanks. Now, Mr. Joseph, I'm looking here at a sales ticket here. It's a confirmation, and it refers to Otter Creek Associates, address 9560 Wilshire Boulevard, 4th floor, Beverly Hills, California. I'm looking at another one, and the first one was, was with regard to Texstyrene. Second one is with regard to Texstyrene, and this says Financial Investments, a California limited partnership. 4th floor, 9560 Wilshire Boulevard. Attention, C.L. Lageman. The next one is Concordia Investments, Associates, 9560 Wilshire Boulevard. This is the address of your high-yield bond department, is it not?
It's the address of our Beverly Hills operation in Los Angeles. We have a corporate finance department, a retail branch, a mortgage-backed securities branch, a number of activities out there.
It's a high-yield bond department, is it not? 4th floor?
4th floor, I think, is in fact the high-yield bond department. I'm sorry, I was thinking about the address, not the floor.
I'm curious, who is C.L. Lageman? Is she an employee of Drexel?
I don't know the name.
Would you submit that information to the committee, please?
Yes, we will.
I believe Concordia Associates, or Concordia Investment Associates, started in your New York office. Is that correct?
No, Concordia was corporate finance, a group of the corporate finance professionals. The corporate finance department is a national department. It has locations in Beverly Hills, Boston, San Francisco, and New York. New York is the largest
The original account statements, though, of that particular entity were sent to your corporate headquarters at 60 Broad Street, were they not?
I don't remember that, but it's quite possible they were.
And they later moved to the Wilshire address in California.
That may well be the case.
Now, with regard to these insider accounts, are they charged rent by your company?
No, they're not.
They are not.
I don't think they are.
Are they charged for electricity?
I don't think they are.
Are they charged for use of computer time?
Not that I know of.
Are they charged for postage?
Not that I know of.
Are they charged for employee services?
Not that I'm aware of.
Are they charged for any goods, services, activities of Drexel or any of its employees, or the use of any of its equipment, its automobiles, or its postage, or anything else?
I don't think so.
Do they have employees of their own who are working within Drexel's facilities?
I don't know. They may, the name of that person you name may be an accountant that may be keeping the records for the partnerships. I simply don't know how the accounting is done.
Is there any evidence that they pay any of their own expenses, or that they provide any of their own staff or computer use or space anywhere?
Again, I don't know if they have a separate accounting office or not. I know when the partnerships were first formed that there were some legal expenses, which I think I recall were paid individually by the partners.
Their legal expenses are paid individually by the partners.
The partnerships, perhaps.
Or by the partnership. Are any of the other expenses of these insider accounts paid by any of the insider accounts?
Well,
rent, heat, light, telephones, computers, mail, postage, employees, Social Security, security that is afforded them, or courier services, or any of the other things?
They are, first of all, they do pay commission costs.
They pay commissions, but do they pay anything else?
But since they pay commissions,
they pay commissions.
They
pay the same commissions anybody else pays.
But that would make them a customer of the firm from that point of view. Secondly,
wait, they pay the same or they pay different?
I believe their commissions are the same as others.
The same as everybody else. Do they make any other payments to the firm?
Excuse me?
Do they make any other payments to the firm of Drexel Burnham Lambert?
Not that I'm aware of, although it's possible they do. I simply don't know I don't know that they do.
None.
Mr. Chairman, it might be useful if I point out we are a private company. And as such, the participants in these partnerships are important employees of the firm. And I don't think I'd be terribly troubled if they were, for example, using some of our secretarial staff occasionally to help them, type up their annual balance sheet or statements to our employees.
I'm just trying to find out what is the relationship of these insider accounts to Drexel, whether they are independent entities or whether in fact they are Drexel. Do you know what the cost of maintaining any one of these insider accounts is?
No, I don't.
Do you know what the overall cost of maintaining these insider accounts might be in terms of telephone, computers, employees, space?
I don't know, but I would estimate that it is not terribly substantial.
Could you submit to us what is the cost of these firms, either in toto or any of them, with particular emphasis on Otter Creek and Concordia?
We will, to the best of our ability to determine it.
What charges are assessed against them for services and other and goods supplied to them by Drexel?
We will do that to the extent we can ascertain the answers.
Gentleman from Oregon? Gentleman from Florida? Ms. Joseph, do you have any interests of your own in these insider accounts?
No, I do not, sir.
None. Are you the only one in Drexel who doesn't?
No, sir. I'm one of approximately 10,165 people that do not.
Why are you not?
Would you want to tell us why you're not a member of these?
I'm not sure I did. When these were first set up, I think we did discuss this morning, Mr. Chairman, but when these were first set up, I was head of corporate finance, and as such, I wanted to be able to, I wanted to be able to clear any investments they were making to make sure there was not going to be any inadvertent stumble into their investing in a company where some other members of my department might be working on a merger or have inside information that with hindsight would look as if we were abusing that information. And I felt I would look more like Caesar's wife if I was not an investor in these funds where I was trying to make that determination. And I was always concerned that given the size of the corporate finance department, I might someday make a mistake. I don't think I did. But I thought it sure was better not to be a beneficial holder if I ever had to explain a mistake.
You're trying to avoid then conflict of interest, questions associated with your handling of the business of Drexel, and conflicts with regard to particular issues of securities of different types that you might be handling. Is that correct?
Yes, sir.
I'm curious, why is it that we can assume then that you would be apprehensive about these matters when, let's say, other officers, members of the board, the executive committee, persons who handle these high-yield securities, and persons who allocate these high-yield securities have no such concern?
Because in determining who is making the policy decisions, we want the policy decision makers in the firm to have as their agenda the welfare of the firm in its entirety. So that the senior officers of the firm do not have incentives tied to specific departments and not allowed to participate in specific transactions without clear approval from independent other senior officers.
Is a member of an insider account.
Now, you testified this morning that the current head of corporate finance is a member of one of these insider accounts. How is he different than you?
I'm his boss, and I didn't have me as my boss. I had been very instrumental in building that corporate finance department. I was an investment banker, and I'm familiar with the accounts and the transactions that have taken place, and was really the final arbitrator at the time we formed Concordia in what was or wasn't appropriate as an investment. When I became chief exec, I continued to exercise some of that overview responsibility so that Mr. Batchelor, on the easy decisions where he knows there's a transaction, he'll say no. If he's positive there's not one, he might say yes. If he has any question, he comes to me, and he comes to me quite regularly and lets me make the decision even today.
What does a director of corporate finance do?
He runs the corporate finance department.
Does he make none of the decisions that you make which would affect the interests of Drexel? Obviously, he doesn't just sit there. He runs the department. He must make some kind of executive decision. How is he different than you? And what does the corporate finance department, which he runs, do?
It does the investment banking functions. I was not worried about conflicts between the investment banking function and the corporate finance people being investors in bonds issued by clients. I just simply wanted to be sure that someone who had no interest could make the final determination whenever there was a close question, is this an appropriate investment for the corporate finance partnership? It's only in that area that I'm talking about my wanting to be in a position to make the decision, be independent, and I've remained in that position.
I have heard and understood everything that you have said. You have not told me anything which tells me that he doesn't do many of the things which you do, which you regard as precluding you from belonging to one of these insider accounts. I am curious what he does that you, or what he does not do that you do, or what he does that you do not do that would suit him to running the Division of Corporate Finance and at the same time belonging to one of these investment clubs.
I don't think being the head of corporate finance and belonging to an investment club is the problem. The problem was that I had no place to clear the transactions because the senior officer of the firm...
Do you then approve all of his actions to assure that there are no conflicts?
No, only with respect to the partnership investments where there may be an issue.
So he regularly then brings these issues to you for clearance?
It's not very often,
Not
Mr.
very
Chairman.
often. Has he ever done so?
Yes, he does do it. I'd say it happens perhaps a few times a year.
A few times a year.
He's careful to do it.
Are these done orally or are they done in writing?
They're done orally. He does it meticulously when it should be done, and I have total confidence in his integrity and his concern about the propriety, and I'm sure that he's come to me.
So there is no
each time
paper
he should.
trail on this matter?
No, there is no paper trail.
Mr. Chairman, how many partnerships does he belong to?
I don't know. I would guess he probably belongs to something in the order of magnitude of 5 or 6 or 7. I'm guessing, but I think it's a few.
And I still wasn't certain, and the chairman, I think, is addressing an important point. When he engages in investments in those partnerships, he brings them to you to have them cleared, and all of them are cleared, or how are they handled?
Now, if there's a question whether the partnership should make an investment in a security of a company that is a corporate finance client, and there's any activity that might be going on with that client, merger and acquisition search or a possible public offering, he will come to me, tell me the facts, and ask me if I think it's appropriate or not for the partnership to invest in the security.
But he only comes to you a few times a year, you said.
That's right.
Well, there seems to be a lot of activity in these partnerships, and Mr. Chairman, perhaps we could, given the lateness of the hour, inquire some more about this on the record, because I thought he belonged to only 2 or 3 partnerships, and according to what Mr. Joseph said, he now belongs to...
I was guessing it could be as few as 2 or 3.
It could be more than 5.
It could be more than 5. I don't know the number he belongs to.
I would like to know more about how someone in his position, top position, handles his own investments in these partnerships, and perhaps it could be given to the committee in writing.
Chair, thanks. Gentleman from Florida.
Mr. Chairman, I don't know that I have, this thing's falling apart on me. I don't know that I have any more questions, but first I would ask consent that we can submit further written questions to Mr. Joseph. He might respond to in the record and become a part of the record. But the additional thing is, I know I asked that very multifaceted question earlier, and I suppose there are others. Is there going to be a time period here within which we might get expect responses? And I don't want to be unfair. I'm not really sure. Yeah. Well, I don't want to be unfair, but I'm concerned about a time period here. When might we expect responses?
I'm not able to give you an answer. We will try and proceed rapidly on this matter as we can. We will try and see to it that the answers are available and that the record is available to the members as soon as we can. And we'll try and make whatever judgments need to be made with regard to further proceedings by the subcommittee as soon as we can.
I guess that's good enough. Thank you.
I simply am not able to give you an answer.
Thank you, Mr. Chairman. I don't know. Would you care to answer that, Mr. Joseph, insofar as that multifaceted question on Phillips Petroleum? When might we expect
as
something?
quick as it's feasible. I think we'd have to look through the list. Some of these might be fairly complex, and we'll provide the information as we gather it, as quickly as we can.
Mr. Chairman, we had anticipated that we would get a staff report before the hearings and then make a submission to you, which would be available at the time of the hearings. And in view of the nature of the hearings and the fact that material has just been furnished to us, we would like to make a submission, which we'll make quite promptly,
Chair will
dealing
be
with the
happy
issues.
to receive any additional comments you want to make, and we will review them and probably insert them in the record.
Thank you.
The Chair has made available to you, as you know, gentlemen, the first draft of the information was to be made available to members of the committee. That has been made available to you at Drexel alone and to no other person.
That was done in order to enable you to have the information would be available to the members at the earliest possible time and to be available to you so that you might be able to give the best and most informed testimony with the least surprise to you. And we have sought in that particular to be fair, and as I have iterated earlier in my comments, we did not make that information available or that document available to any other person. The gentlemen, there's a vote on the floor. Mr. Joseph, you have been here a long time. You have not had the easiest time, as I'm sure you're aware. The Chair wants to thank you, Mr. Fleming, Mr. Schneiderman, for your presence, your assistance, and for your patience. Thank you, gentlemen.
Thank you, Mr. Chair.
The committee will stand adjourned until the call of the Chair. Ron?
If you have further questions or comments about this program, you can write to the House Energy and Commerce Subcommittee on Oversights and Investigations. The address is 2323 Rayburn Office Building, Washington, D.C., 20515.
Each weekday, C-SPAN breaks from its public affairs programming to give the viewer updated schedule information. Join us at 8 o'clock a.m. Eastern, 5 o'clock a.m. Pacific Time,